participate, but I'll be listening in.
Okay, no problem. Okay, so we will get started and I guess the others will join us shortly.
Yep.
Okay, just a review of last week. Just for a recap, I guess Siobhan, Nathaniel is not able to engage. The trustee, what's the trustee's general duty?
To account for trust property.
Excellent. So the trustee has a general duty to account for the trust property.
Mhm.
When the trustee advanced trust monies, what is that all about?
The advancement is them getting a large payment from the capital.
And who can get that?
Pardon me?
Who can get an advancement?
The capital,
The
the life
beneficiary,
remainder,
The capital beneficiaries, right?
right?
And what we may be doing? What we may be doing to give them this advancement? What we may be doing for them? Why we advance in such a large amount?
Well, they will need to be buying a large, like buying a house or for a business or something like that.
Okay. Now, if we had an expense that's repairing a house, which is a part of the trust asset,
Mhm.
who would that expense go to? The income of capital beneficiary,
Capital, yeah,
capital beneficiary.
right.
What about appropriation? What do we do with appropriation?
Appropriation. That's apportioning the trust assets for a specific purpose. So I guess if they want to,
So we appropriate a portion of the trust assets. Would we doing it for what we may do when we appropriate it? Who we need how can we do this? We need consent of the beneficiaries?
yes, we do. We do need consent of the beneficiaries. in order to
Unless there
appropriate.
is what?
Unless there's something in the trust instrument
That gives us,
that gives us authorization to
what
do
is
it.
it? What we have or what? What
A
kind
power.
of, right, a power of
For power of
appropriation.
appropriation.
Excellent. Now, income beneficiaries, what they get, what will count, what we count for their income?
Dividends, bank loans, investments, like the
So we get income, they get income from rent. They get income from what else? Stocks, dividends. all
right,
of
some
this, right?
stocks, dividends,
Okay,
investments.
and what the capital beneficiary may get as income?
Capital. I guess if you was to have those on, no, I don't know. If you was to sell some of the properties that's
Right.
in the trust instrument,
So we perhaps can give them a distribution of capital based on us having something of some substantial moment
right?
where we may have we sold an asset
Uh-huh.
And we can give them something out of that.
Right.
So what we use as an example,
They could sell a house.
right? And what we'll do when we sell it, we'll try to do what? Appreciate the capital a bit more, right? We'll go up a bit more.
Right.
We'll try to get, use that money to increase their assets, or we may advance them some money, eh?
Right.
Now, what are the considerations we take into account? When we when we dealing with income from the trust property, what are the important considerations we take into account?
The beneficial interest.
When we're trying to distribute our income, go ahead.
Right, the beneficial interest can be entitled to income.
Right, but what do we consider before we do any distributions?
We have to take account of overhead expenses, eh? Liability.
So we have an example of what is where we, okay, let me put it. We want to know how income will be either retained or accumulated to where we accumulating or retaining income. Why would we consider in accumulating or retaining income?
The proper accounting of the gross income.
Right, what else?
The extent to which income may be paid.
Uh-huh.
The power of the trustees to accumulate or retain income,
Mhm.
and beneficial interest which may be entitled to income.
Okay, but and before we could distribute income, we have to take away the what?
Expenses
Excellent.
attributed to the income.
Okay. Now, what is what we dealing with about the trustees keeping records, accounting records? How long do they have to keep accounting records?
5 years.
Is there a penalty?
There is $2,000, not
Yes.
exceeding $2,000.
And what section deals with that?
Section 2,
Right, section 2 of what?
the trustee amendment.
Okay. All right, so I think we recapped Unit 10. Look like you all have a fair understanding of it.
Yeah.
Okay, good stuff. All right, let me just do the register quick. I give them a little chance to come in. I see one more person came in.
Good morning,
Good
everyone.
morning. How you doing?
Good morning.
Thank you.
What is your last name, please? Siobhan
Kelly.
Kelly, okay. And Alicia Wilson, I see up here. Okay, so I have 3 persons so far. Okay, so we're going over Unit 11. Good morning, Alicia. Nathaniel isn't able to engage with us, so it's only you and Siobhan to help me out with a little bit of reading. We'll try to get through it a bit quickly, since we have a little bit more to go through. But I think we'll get through it fairly quickly. Okay? Any
Okay.
questions from last week, or are we good?
We good.
Good. Okay, after we complete Unit 11, we should understand the powers of investment in the trust instrument, understand the statutory powers of investment, and obtain information on the law relating to trustees and investments. If you had a chance to look over this chapter before we started, you'll look at your study resource list at the end of the chapter. And it tells you which sections of the Trustee Act we're looking at, the cases we're looking at, and it will give you a fairly better understanding of the principles derived from the cases, because then, you know, we have common law, And we have law that's derived from statutory. So it's statutory law and then the common law. So the common law comes from where? You all did that?
I don't remember that one.
The
Yes,
common law
common
we get
law came out of equity law.
No, so the common law comes out of our cases, when we get our cases, what is common practice in the cases where they've derived from there. And the statutory law comes from our acts. So the act will direct us on what is statutory, and then we'll have cases that will interpret the act, or the act will take some information from and we'll use that for common law. Okay? Okay, so let's start. Siobhan, please.
Okay. Trustees invest trust funds in order to provide an income for the income beneficiaries or capital for capital beneficiaries. The trust investment often provides express powers of investment to the trustees. In the absence of these express powers, or where such powers may be limited in terms of the various ways trust funds may be invested, the Trustee Act 1998 provides guidelines to trustees on investing trust funds.
So where the trust instrument doesn't provide, the Trustee Act will give us guidance, on
Right.
how we can invest the trust funds. And they'll give us the particular section that deals with that later on in the chapter.
Right.
Okay, go ahead.
At the center of investing trust funds is the trustee's goal of protecting and preserving the trust from needless loss and fully realizing the returns on the investments that may be beneficial to the trust in meeting the needs of the income and capital beneficiaries.
So the
The
trustee is responsible for protecting and preserving the trust from needless loss and fully realizing the returns on the investment. And that's because he needs to meet certain things, and those things are what is he doing? He's ensuring that he's able to
I guess keep the trust going,
and meet the needs of who?
the beneficiaries.
Income and capital,
Right.
Okay, go ahead. Now this is important here.
The standard of care for trustees in respect of their duties was stated in Spite versus Gaunt, which is to take such as an ordinary prudent
That should
man.
have been care. That should be care.
Okay,
Mhm.
which is to take such care as an ordinary prudent man would take if he were under a duty to make the investments for the benefit of other persons for whom he felt morally bound to provide. In the case, Lord Watson explained that as a general rule, the law requires of a trustee no higher degree of diligence in the execution of his office than a man of ordinary prudence would exercise in the management of his own private affairs. Yet he is not allowed the same discretion in investing the monies of the trust as if he were a person sui juris dealing with his own estate. Businessmen of prudence may and frequently do select investments which are more or less of a speculative character, but it is the duty of a trustee to confine himself to the class of investments which are permitted by the trust, and likewise to avoid all investments of that class which are attended with hazard.
Okay, so we have, this is important. That's what you would use as your definition if you were just giving an answer on the standard of care for trustees. So the standard of care for a trustee is stated, it came out of Spite and Gaunt, the legal case of Spite and Gaunt, which says his duty is only to take such care as an ordinary prudent man would if he were under duty to make the investments for the benefit of other persons for whom he felt morally bound to provide. So he has a basic duty to ensure that he would take care as an ordinary man. So the same way you would take care in your business affairs to ensure that your investments, your money is invested properly. You should have that basic standard of care. But in the case, it outlays a bit more to say he is not allowed the same discretion in investing the monies of a trust as if he were a person just of age or a prudent man would. That's sui juris. So what sui juris wasn't, you all did that earlier, eh?
Yes.
Okay, what it is. Just of age, the person came of age, eh?
Right.
So you sue jury dealing with his own estate. So you have a higher standard of care because you cannot, as an ordinary man, you may do things like invest in things that are a bit risky.
Right.
But in the case of a trust, what you have to do?
You'd have to do, I guess, your due diligence, you know, like if he was to do it on his own, he would take the risk. But because you have the beneficiaries to consider, not yourself, you'd have to do more due diligence when it comes to you making these investments.
But what the case tells us, what he has to do, he has to confine himself to what?
To the class of investments, which are permitted by the trust.
Right. And he has to avoid
all investments of that class, which are attended with hazard.
Okay, so he has to follow the terms of the trust as per what they set out for investments. Remember, we said some trusts may say, I don't want to go into anything speculative. I want you to stay on conservative investments. So if he goes outside of that, then what happens? He's in what?
He's in breach.
Right. So if I say I'm a settler, I am a Muslim, and at no point should you invest in anything that would go against my religion, and I'll particularize what I don't want you to do. I don't want you to invest in things that where women, I may be of the view that women should not be in charge. So if a woman is in charge, I don't want anything to do with it. I don't want you to deal in things that are against my religion. You may they may be selling meat. I don't want you to, if that's a company making $10 million, I could care less. Don't put me in that. Yes. So
Right.
you have to stay within the class of investments that the trust directs you to invest in. If you go outside of that, then you are now what?
In breach.
Right. And you have to avoid investments which are what they call?
Of that class.
Right. So and you have to avoid what kind of investments? Ones that are what? Risky?
Yeah.
So avoid all investments of that class which are attended with hazard. So that's what they call in risky. Okay. So what we have the standard of care is, it's outlined in what? The standard of care of a trustee is what? In what?
What you mean? And
Give me the recap of the definition of the standard of care for a trustee.
Well, it's stated in the Spite and versus Gaunt,
Right.
which is just the standard of the care of trustees.
So give me,
It's the-
summarize the definition to me and tell me how we would say it if we were answering a question. I'm asking you, what is the standard of care for trustees in respect of their duties? We starting off our answer with the standard of care of for trustees in respect of their duties was outlined in the legal case of
Spite versus Gone.
which is they should do what?
The take
Take
Yeah,
care.
but-
take
Mhm.
as an ordinary prudent man
Mhm.
when it comes to making investments for the
Investments,
benefit of
yeah.
others.
For whom?
For the beneficiaries.
For whom he felt morally bound to provide. So we saying what their duties would be in the setting of a definition. So who you may be morally bound to provide for as a regular person, as an ordinary prudent person.
Yourself,
Who else?
family,
So you have children you may be morally bound to provide for. So you would take ordinary care to ensure that you have a roof over their head. You have funds to take care of their education if you need it, all of that stuff. So that's being an ordinary prudent man and taking care that you invest in things that would now assist or provide for those you are morally bound to it. That's your
Right.
children.
Mhm.
So that's the easiest way of putting it. So what is the next part of that? However,
Mhm.
he is what? Hello? What's the second part of the definition?
is
We
not
might-
allowed the same discretion in investing money as dealing with somebody who's suturous.
Mm-hmm. No, what is he not? What is the second part? So he can make investments.
Oh, he have to confine himself to the class of
class.
investments which
Right.
are in the trust.
Okay, so as a businessman, I
Mhm.
may now do what? I may invest in things of a speculative nature. I may take risky investments because that's my own money, eh?
Right.
But in the trust, what I have to do, because they said as an ordinary prudent man of business, what, but because I'm now confined to what?
Confined to the class of
To the
investment,
terms of the trust, which tells me what,
which investments they want him to take.
right? Now, because of that, I cannot do what?
You can't be as risky,
Right, I have to
That would be-
avoid investments that don't fall within that class. And I
right,
can't take the risky
that
ones
risk.
within that class.
right.
Okay, good. So you think you understand the principle derived from Spite and Gone, which deals with what Spite and Gone deals with
Standard care trustees.
in respect of
Like,
their,
of their duties. Sorry.
excellent. Okay, let's move on to the next.
In Cowan versus Cargill, 1984, 5 of the 10 trustees of a mine workers pension fund refused to accept an investment plan submitted to the trustees by a panel of experts on the ground that the proposed investments were in energies which were in direct competition with the British coal mining industry. And
That
that
should
it was,
be competition.
sorry,
Okay, you
We're
just have it
indirect.
wrong. Yeah, just have it wrong, misspelled.
were in direct competition with the British coal mining industry, and that it was the policy of the National Union of Mine Workers who had appointed the 5 trustees not to invest in competing industries. The court held that the trustees would be in breach of trust if they failed to adopt the recommended investment strategy, which were not entitled to base their investment decisions on purely ideological grounds. And the principle established is that it is the primary duty of the trustees in deciding how and whether to invest trust funds is to act for the benefit of the beneficiaries and in the best interest of the trust, both present and future, and if the purpose of the trust was the provision of financial benefits A power of investment ought to be exercised in such a way as to yield the best financial returns by way of income and capital appreciation. McGarry VC said, trustees may have strongly held social or political views. They may be firmly opposed to an investment in South Africa or other countries, or they may be object to any form of investment in companies concerned with alcohol, tobacco, armaments, or many other things. In the conduct of their own affairs, of course, they are free to abstain from making any such investments. Yet under a trust, if investments of this type would be more beneficial to the beneficiaries than other investments, the trustees must not refrain from making the investments by reason of the views that they hold.
Okay, so now we go to Cowan and Scargill. So in Cowan and Scargill, what is happening now? We had what? A trust that has been established for who?
Mine workers,
Pension fund,
yeah.
right? And what happened? What these mine workers doing?
I guess they didn't want,
They in the coal industry, eh?
right, and they didn't want the trustees to make investment in that industry.
No.
Mm-mm.
What happened here is they are in coal. They mine in coal. Now the investments were to be in what?
Competition with the British coal mining industry.
What the competition was?
Energy is
Right. So energy. What you derive from energy? What they used to use coal for?
For light,
Now we going into what? Electricity. So we using what? Probably oil and gas or
Yeah.
something.
right.
So we going to now invest in oil and gas, and these fellas still down in the coal mine trying to dig out coal.
Mhm.
So now you taking their money and gonna give it to their competition. Say you invested in that. So what that means, you have more confidence in the competition than us. And now you funding our competition with our money. So who's gonna come out on top?
a competition.
Right? So what they say? What was the clause in the trust agreement for them to not do what?
Not to invest in competing industries.
And so what we say about in Spike and Gond? He has to confine himself to what?
To the class of the investment
Which are permitted by the,
trust.
That's
so these are not permitted by the trust to go into compete to the competition, eh? You can't
Right.
invest in competing industries. So what the court says, the trustees would be in
breach of trust.
Breach and breach.
if they fail to adopt the recommended strategy. They can't base the fact, as much as they may be saying, you know, something, basically we see that you could make more money if you go into this industry. That means they take their position as they would as a businessman, but can they do that in the trust instance?
No,
Because what they say about that? When they decide how to invest trust funds, what they have to do?
you have to follow what the trust instrument says,
Right, it has to be for the benefit of who?
the beneficiaries,
And in the best interest of what?
of the trust.
Both present and where? Future, right?
Yeah,
So what we have to do, yield the best. We talking about what? We still going over the definition. We have to yield the best financial returns by way of,
Mm.
you all following me?
I don't think so.
Okay,
Where you reading from?
we reading the same
Or it's
Definitely.
on Spike from Spike
From
versus Gone?
Cowan, we in Cowan now.
Okay, right.
We have the yield, the best financial returns by way of income and
Capital
Capital
appreciation.
beneficiaries.
so let's be on right before McGarry. We have to yield the best financial returns by way of income and capital appreciation. You
Right.
see that?
Yes.
So
No, sorry. When you say
Right.
read it again?
right before McGarry, VC said under Cowan and Scargill.
At the top of page 86, right?
Yes.
Okay, thank you.
So as much as the trustees may hold social or political views, can that be a deciding factor in them making trust investments?
No.
Yes or no?
I say no.
Okay, no, because that only can come into play if that is a part of the what?
The trust instrument.
Right, where they give you directions on how. So if they say to invest in oil, in the oil industry, and it may have been in Russia, unless it's against the law, we have to go into,
Oil industry in Russia.
okay. So you may hold your own view that I wouldn't do any business with Russia, but if it's not against the law, we can go ahead and do it, because the trust fund, the trust instrument provides for the class of investments we may go into. So your social or political views as a trustee do not factor into making decisions, because then what are you doing? You are now in what?
And breach?
You're in conflict, You conflicted because what you're doing, you putting your personal interest
About that of
Oh.
the beneficiaries.
before the beneficiaries. So you can't be conflicted. You can't be conflicted in your duties. Okay, Siobhan, you could finish off the last sentence.
It is recommended that where trustees may be doubtful of their duties and responsibilities regarding the investment of trust funds, they should seek appropriate legal advice. Nassau versus National Westminster Bank, 1993.
So when I'm in doubt, I go ahead and seek the legal services. They'll provide me with an opinion. And then I'll know how to move on that. So where the trustee is unsure of what their responsibilities are regarding investments of trust funds, they now can seek legal advice. And the case that helps them in going ahead and doing this is Nassau versus National Westminster. Any questions on that so far? We understand the trustee's duty and how they can't conflict and put their social or political views, right?
Right.
Yes.
It's more clear
Very
now.
much for me.
Yeah.
It's better?
Mhm.
Yes.
Excellent. Okay, next is Alicia.
Okay. Trustees' investment duties. In trust law, trustees are expected and required to act as a prudent man of business with regard to the investment of trust property on behalf of the beneficiaries of the trust. To supplement this standard of care, trustees must perform certain established duties in relation to the investment of trust funds. Namely, a trustee must not invest in risky or hazardous investments unless expressly provided in the trust instrument. A trust must have full information about an investment before he makes it. A trustee owes a higher standard of care where it is a professional trustee carrying on the business of providing advice and managing trust funds. Bartlett and others versus Barclays Bank Trust Company Limited, 1980. A trustee with a power of investment should undertake periodic reviews of the investments held in trust. The review should take place at least annually. Nestle versus National Westminster Bank PLC, 1993. Where the purpose of the trust is to provide for the financial assistance of the beneficiaries best interest will usually be their best financial interest. Cohen versus Scargill, 1985. It has been decided by the UK courts that only where moral considerations do not affect the financial interest of the beneficiaries should they be taken into consideration by the trustees. Harries versus Church Commissioners for England, 1992.
Okay, so now we have what supplements the standard of care. So this is what we'll use in addition to what Spiden tells us, what Cowan and Scargill tells us.
Mhm.
We'll now use these important considerations when we are making decisions as to investing the trust property. We should not invest in risky or hazardous investments unless it is expressly provided for in the trust instrument. We should have full information about about the investment before we make it. Now, the trustee has a higher standard of care. So as much as you have a standard of care, the trustee is held to a higher standard of care when they are professional trustees. So when you're selling yourself to be this professional, that means you are out there saying we are a trust company, and you as a result solicit clients and they come into your establishment. Based on that, they hold you to a higher standard of care because these people believe you are an expert in this area. And as a result, they've entrusted their funds to you with the understanding that you know what you're doing. So you are held to a higher standard of care. And Bartlett and others versus Barclays Bank Trust Company Limited gives us that definition. That means as a trustee, you may have chosen me as a friend to be a trustee over your investments. Now, am I selling my services?
Repeat the question, please.
I'm a testator.
Mhm.
I put my friend or my sister or somebody to now run my business when I die and to take care of my family. Would I be held to a higher standard of care as a professional trustee?
No.
No, because I'm not selling that service, eh?
Right.
You asked me to do it as a friend. Now, unlike I'm going into, which one are we at? Butterfield. Somebody's at Butterfield, right?
Right.
Butterfield is now selling their services. When I come into them, what I expect them to know what they're doing, eh?
That's correct.
And if they don't know what they're supposed to do. Because they sell in the service now. If I don't know something, what I have to do?
As a
I-
trust-
Seek professional advice.
Right, we hire people who know. So
Right.
we hire investment advisors, we hire custodian, we do all those things, eh? And then when we don't know about investments, if we can do certain things, what we can do? We can get a what? When we are doubtful of our duties as it regards investments, what we do? What Nestle versus National Westminster tells us?
Seek legal advice.
Okay, so you see, when you pull these things and you see how much better your answer sounds? You getting what I'm saying?
Mhm.
When you could pull these things back, these principles back, if I'm doubtful of my duties, I can now,
Seek legal advice.
in accordance with the case of,
Nestle
Nestle
versus
International.
National
so now you
Investment.
get 2 extra points right there because you show them you understand this whole area well, eh?
Okay.
Now, the trustee with a power of investment has to take periodic reviews. And that's again established in the case of,
Nestle versus National Westminster.
and that should be done annually. So usually when you're a trustee, an administrator should have a review of the trust annually. So you're supposed to ensure that you're keeping with the guideline. So you should have a sheet that you use to go over the trust annually. That should be a part of your due diligence in you dealing with the trust. Everybody should have annual reviews. I don't know, anyone's working in trust now?
I am, but I
So
mean, I
y'all
work
do-
at a trust company. Let me put it
Okay.
like that. Mhm.
Okay, y'all have to do annual reviews of the trust,
Yes.
eh? Yes,
Yes,
so that's the principle established in
Nestle versus National Westminster.
at least annually, there should be a trust review. And where the purpose of the trust is to provide for financial assistance. What is the beneficiary's best interest?
The best financial interest.
Okay, so whenever we talking about in the best interest of the beneficiaries and for their benefit, it is for the
Best financial
Financial
interest.
interest.
excellent. Now, when we take it into account their best financial interests, do moral considerations affect that?
No,
So it's only where moral considerations do not affect the best financial
Financial
interests,
interest.
could they be taken into account? So morally, if it's morally right that we should not invest in Russia, but it's financially viable that we should, which one will come first?
the financial.
Financial,
Excellent, because we are to do what the purpose of the trust is? And what we talking about now, the purpose of the trust is to provide for the financial assistance of the beneficiaries. So their best interest in this instance is what?
it'd be the financial over the moral.
The best financial interest.
Interest, okay.
So when we talking about the best interest in the case of a financial assistance, it is what kind of interest we talking about?
The best financial interest,
Right, so that's what I'm asking you.
okay.
When we're talking about the best interest of the beneficiaries, where we have to provide for them financially, what is their best interest?
The best financial interest.
Okay, are we concerned about whether they go to school, whether they do, what is our consideration?
The consideration would be for the financial interest,
That's it. That's all we concerned about, their best financial interest.
okay.
Okay? Okay, let's continue.
Okay, express power of investment. It is a general principle of trust law that express powers of investment within the trust instrument will be construed by the court according to the ordinary and natural meaning of the words used. Under the equitable principle that he who asserts must prove, a trustee wishing to argue that a particular investment falls within an express clause within the trust instrument must prove that it actually does. Re Haran Settlements Trust, 1949. There are certain investment clauses which also give trustees the power to vary investments, which is said to be an implicit power nonetheless. Re Prattsville Trust, 1943. A power of investment which requires the consent of a third party may also be allowed. Revised 1954. However, such a power may not have any fiduciary obligations attached to it due to its very nature, unless the context within which the clause appears requires it.
Okay, so we have express powers of investment now. So the general principle is that express powers of investment within a trust instrument will be construed by the court according to the ordinary and natural meaning of the words used. So just what it says is what the court will say. That's how the words are used. That's what it means. So if they say the trustee may invest in, let's say, conservative investments. We know conservative means conservative. It's nothing risky. It should be low key. It shouldn't be anything out of the ordinary. So it's not for now somebody else to say, well, that's not conservative, because conservative will be relative to, I guess, who is the person saying it, eh? But the ordinary meaning within the trust context would be, it is a conservative investment. And based on you working with a professional trustee, conservative means this, that, and the other. It doesn't mean more than that. So the equitable principle says he who asserts must prove. So if me as a trustee wants to say that this investment, conservative investments, falls within the express clause, I have to prove that that's what is stated within the trust document. So this is like, I'm going to court now. I'm asserting that you stole something from me. I have to prove it, eh? So that means whoever asserts must prove. So the trustee is asserting that, yes, I fell within the express clause of the, I fell within the express clause that was provided for in the trust document. They told me I can invest in this area, and that's what I did. What he has to do now? As a trustee, under the equitable principle. If the trust says you can invest in conservative trust, if you can invest conservatively.
So
And
would it be better?
he's now invested in something which seems risky to someone else.
Mhm.
He has to prove that.
Yeah, he has to prove the equitable benefit of the investment.
So now I am a trustee. I'm a trustee, and the trust instrument expressly provides that I can only invest in conservative investments, right? Give me an example of a conservative investment.
Government bonds.
Government bonds. Okay, that's conservative. What else? What could be borderline conservative and risky?
FTX investment.
That's real. That's real.
risky. That's risky.
Right. What else we could try? What is conservative but on the borderline?
Now you got to realize now, FTX wasn't a risky investment a year ago. So only
Man, that was
because now that
risky from you get it started, because there's no way you could
no, man, with
the
all,
money
with
in
all
a
that
minute.
hype was going on with FTX, man, everybody was buying. That's how everybody get full.
That's the hype. So anything what too good is what seems
Andrew?
too good is too good. It is too good to be
Good.
true. So what we need that is borderline conservative and just a bit on the risky side. What we call? What about a mutual fund that's just a bit risky? Something just above, just on the borderline of shares and being risky, a mutual fund. The mutual fund may be the owner of what? What about investing in Facebook? Would you consider that conservative? Apple. Would you consider that conservative? Anybody?
I think Apple is more conservative because their clients can stick with them.
But it could be risky, eh?
Yeah, it could be risky. Somebody might
So
come up
let's
with a
use
better
Apple
plan.
as an example then.
Yeah.
So now the trustee invested in Apple. Now what happens? He's having to use the equitable principle. He who asserts must prove. So that means somebody having where?
In court.
Okay, because when you see this comes in, he have to prove something. So now that he has to prove, what he has to do? He
You
has
have
to
to
prove
show, you have to
that-
show that Apple, even though it seems that it's risky, it would be considered,
it still
conservative
falls
as
within the class of investments as set out
right,
in the trust instrument, eh?
right.
So he has to show that this investments falls within that class, within the express clause of the trust. So the courts will say what? What they'll use in determining where he falls within. They'll take the ordinary and natural meaning of the word. What? What word we talking about here? Conservative? You all following
Yeah.
me?
I got you.
Okay, so the court looking at the ordinary and natural meaning of the word conservative, and the trustee is now proving that conservative could mean shares in,
An apple or an
Because-
apple.
because Apple is usually a safe bet, eh?
Yeah.
Yes,
It's been stable for, so
For a
I'll have to
while,
show
right.
that Apple has always been stable, and the only thing that's been doing is they go climbing up. It's not ever proven to be nothing more than that. So me as the trustee would have to prove that. So you get what that example is?
Yeah.
Okay. Now there are certain investment clauses which give the power to vary investments. The trustee may have power to vary. What is that called? What that power is called?
an implicit power.
Right, so they may have an implicit power to vary the investments. So they can vary it from what? Being what? What the word was we talking about for this one? What kind of investments we making?
Prudent investment.
No.
What kind of
that's
investment? Conservative? We talking
Yeah,
about
Conservative,
we talking about
conservative,
the same one
conservative.
now, remember? This is the example we using. We making conservative investments. The trustees may have a power to do what? What kind of power they may have?
Implicit power.
To vary the conservative
Conservative,
investments
Right.
into something a bit more risky, eh?
Right.
Right,
What case gives us that?
Pottsville Trust.
Okay. So Pottsville Trust tell us the trustees may have an implicit power within the trust instrument to now vary. What about the power of investment? They can have a power of investment from a third party. We talk about this, eh?
Right.
Where there's a power of investment given to a third party. What section of the Trustee Act dealt with that? Trustee Amendment Act. Remember we talked about this last week, where we had a power, what?
Section 2,
No, we talked about somebody last week. Where we talk about this section that y'all didn't recall, but y'all recalled it afterward. I remember about section 13, sorry. Where we had a power holder, where we said the settler may be a settler directed trust. Remember that? With inserted 81A, which gives power holders. You'll have to remember this from last week. Remember when y'all was saying the settler, if he directs something, it may be a sham?
Right.
And we said there was a section of the Trustee Act that dealt with given this, where the settler can now have powers of investment.
Okay.
Section 13 of the Trustee Amendment Act 2011, remember that?
Yes, it does.
Y'all remember that one? No?
No,
We just talked about that last week. When I tell you, I'll go to the page and y'all was supposed to make a note of it. I think it was in unit 2 or something. We went to this last week. Somebody have to remember. This was in unit 2. Right on the second page of unit 2. We did this last week. Go to your second page in unit 2.
It's on page 24, I believe.
And what it says.
Let me go there.
a trustee may be absolved from any liability for loss to the trust where he has acted on instructions or directions of a power holder.
But where we
Fair
look
to
under section 13, I want you to read that.
Yeah, that's page 24.
Okay. What
So
it
under section 13 of the Trustee Amendment Act 2011, TAA, which inserts a new section 81A into the Bahamas Trustee Act
Mhm.
1998 for a settler-directed trust in relation to investment powers. A trustee may be absolved from any liability for loss to the trust where he has acted on the instructions or directions of a power holder or failed to act in the absence of a direction from a power holder with responsibility for investment.
Now you all need to remember this section 8. We don't go over this and you all keep forgetting that, but that's important because this power holder now, this provision was important for settlers. This was important for them to just have an investment person just giving direction to the trustee. So you all need to remember this section 13, okay?
Right.
What is a power holder defined as in section 18 of the same act? Right underneath,
Any person holding a power in relation to a trust,
including,
including a power of appointment, consent, direction, revocation, or variation, and any power to appoint or remove trustees or power holders, and includes a person in the position of a protector.
so you all should know that section, okay? You all should know those things. That's important to know. I mean, just as a basic, so you would know what provisions you have if they wanted to have someone to invest in the trust. So someone may just be coming to you as a trustee to say, well, we want to establish the trust, but we have somebody who can do investments and we want them to be able to direct you on investments. So you'd be able to tell them, well, we have a provision in our act that provides that we can use a power holder in this instance, and they'd have the power of investments, eh?
Right.
So now we should forget that
Excuse me,
section
could I just get a
anymore.
little clarification?
Mhm.
Just for clarification, so that
Okay.
means they won't be considered a trustee, but just a power holder.
They wouldn't consider, say it again.
They won't be considered a trustee, just a
Mhm.
power holder.
Yeah, they're only a power holder. So
Okay,
that means they only have a power to do certain things.
okay.
Remember, the trustee has what?
A fiduciary commitment
So the trustee has duties and,
and power.
right, and which one is fiduciary?
The duty,
And which one they can delegate?
the power.
So we can now delegate a power in accordance with,
The trust instrument.
No, in accordance with what? The law gives us, the statutory law gives us
that-
this
That's the amendment, 2011,
section,
81A.
no, section 13 inserts 81A into the trustee act.
Okay, I get it.
Okay?
Thanks.
So y'all should know that section because that's important. Okay, and is this a fiduciary obligation? When you have a power, are you a fiduciary?
Yes.
Yes, it is, but it's still professional.
No, remember now, what is a fiduciary?
A fiduciary means that you can't do nothing, that is hazardous or risky to your client.
Because that means you have a what? As a fiduciary, you have duties or power?
You have duties,
Okay, remember we
duty of
established,
care.
right? So fiduciary has duties. Does a power attach fiduciary duties to it?
No. It have
No.
professional. It's
There,
professional.
unless we put that clause there,
Mhm.
there's no fiduciary duty of a power holder. Because you're only asking me to do investments. I have no duties to you other than to make investments.
Financial, okay.
Unless you put that clause there to say you, and then I have to agree that I'm gonna be a fiduciary, this will be a fiduciary power I'm holding. Okay? So the power of investment may require a consent of a third party. And Rewise tells us we can have that. So what in this instance, what that means? The power of investment also needs the consent of a third party. Who usually is a third party in the trust?
It'll be the bank.
No, in the trust.
Beneficiaries.
So a third
bank.
party giving us directions. The beneficiary is a party to the trustee. Who's a third party? We just talked about them. The
Power
old
holder.
power holder, and what they used to be called. Protectors, you remember?
Yes,
Oh,
protectors.
yeah.
Yes.
Instructions.
Yeah, so the third party was the protector, so we had to go, before we made some investments, we had to consult with the protector. And the protector may have had power to remove us as trustees as well, eh?
Mm,
The protector may have had power to terminate the trust and all, eh?
mm.
Y'all remember that? Yes?
Yes,
Yes, please, tell me yes. Yes? Y'all talked about protectors before?
yes, we did discuss protectors.
Okay, I want to make sure I'm still up. So now the protector may now be
Third party.
a power holder, hey?
Power holder, yes.
So we may call them, instead of being a protector, we may give them the name power holder. And what section deals with power holders? Of the trustee act, which section?
13.
Section 13 provides for these insertions, but would we, where the power holder is defined in section what?
81A. Is that it?
No.
Section 18.
Yes, section 18 of the Trustee Amendment Act 2011 defines who the power holder is, and section 81A gives us powers of what section
Investment.
81A gives us? Power of what?
Investment.
Yes, power of investment for,
Hold on, let me write. Give me 1 second.
settler directed trust. And therefore the trustee may be absorbed from
Liability for
of
loss.
loss where he has done what?
Failed to act in the absence of the direct power.
Or
Hold on.
acted on
The responsibility for an investment.
or acted on the instructions or directions of the power holder. So whether the trustee acts on the instructions or directions of the power holder, or where he fails to act in the absence of the direction from a power holder with responsibility for investment, he is absolved from liability of loss in accordance with section 81A
81A.
of the Trustee Act 1998 for settler directed trust.
Oh.
Section 18 of the Trustee Amendment Act 2011 provides the definition of a,
Power holder.
and the power holder is any person holding a power in relation to a trust, including a power of appointment, consent, direction, revocation, or variation, and any power to appoint or remove trustees or power holders. So this power holder can actually remove other power holders and includes the person in the position of a protector. One second for me, okay?
Okay.
I apologize. I just had to take a call. Sorry about that. We back? Everybody here?
Yes, ma'am.
Good.
Yes, no, I'm still here.
Okay. Okay, so we go back to now the express powers. I don't lose my page. So the power does not have a fiduciary obligation attached to it by its very nature, but we can put a clause which requires some fiduciary duty, eh? Yes? You all agree, yes or no?
Agreed.
Okay. Any questions? Be clear?
I do have a question. Can you go over express powers again, please?
Okay, express powers. So, which you want us to go over how we got to who he was search must prove, or where you want me to go? What is not clear?
Just the summary you did just now, the definition.
Okay, so where there's express powers of investment within a trust instrument, the courts will construe the express powers by the words that are used within their ordinary and natural meaning. So if you said there's a conservative, the investments in this trust should be done conservatively. It's for the trustee, if he goes outside of that definition, to prove that it is within the clause that it's stated. So he would have to prove if there's somebody taking him to court to say you've breached the trust by going outside of what the investment, the express powers of investment stated within the trust instrument. So now he must prove that he has actually stayed within the conservative clause. So we use, for an example, Apple may be borderline conservative and a little bit risky. And what we said, he would now have to prove by doing what? Showing over a period of time that as much as Apple may be down a bit today, it has always held its ground. It's been a conservative investment that people have always used for time immemorial. You understand that part?
Yes, ma'am.
Okay. Now, notwithstanding, there's express powers of investment within the express trust. That's general principle of trust law, where we could take the words to mean. The trustee may have power to vary the trust investment. And what we call that power, somebody, what type of power?
Implicit.
Yeah, so he may have an implicit power to vary the trust instrument. That means he can move it slightly from being conservative to something more, but that has to be within the trust instrument. Or there may be a power of investment that is within the trust clause that is given, that is where he has the power of investment. He may need the consent of a third party before he can go ahead with the investment. And that third party we may call a, who's the old timer? Who's the old timer in the trust? Who we call the old timer? The third party, the initial third party.
Is this the protector?
Yes, the old timer is the protector. He's been there along with the settler and the beneficiaries from the break, eh? So he may need the consent of a protector before he makes investments, and Rewise tells us that. However, what this power is what?
Implicit.
We may have a power holder as well who have powers of investment. These powers usually are not what type of powers? What are there any fiduciary duties attached or obligations attached to this power?
No,
No,
Unless we do what?
it's in the context.
it's in the context.
So we put it in a clause, eh? To
Right.
say, as much as you have this power, you have some fiduciary obligations attached to it. So what fiduciary obligations we may attach? You should not allow your personal interest to do what?
Affect the financial interest.
Of the trust. So you may now take your, you may say, Lord, this trust should invest in this company to which if they invest, I'll help my company to grow. I may invest in my own company. Should I do that? Only if I put the financial obligation there, eh? The fiduciary obligation. Otherwise, does that stop me from investing in my own company?
No.
As a what though? Who we talking about in this instant? A power holder?
Yes, a power holder.
Right, you remember the trustee cannot do what?
Conflict of interest.
Right, he can't benefit from his position, eh? What
Right.
case tells us he can't benefit?
The trustee act.
No, we have a case that tells us that in addition to that. Y'all would have gone over the case before. What
Mr.
case that-
Quick question. Are we really to know these cases?
It'll be helpful because it helps you just to answer questions quickly if you know the case.
Okay.
You don't have to know it, you only need to know the principle derived from it.
But I mean, being that there are so many cases, like for I guess what's her name, Archer?
Mhm.
She had advised which cases we need to go over. That's how it works, right?
Right,
The
but what-
exam.
right, she'll tell you, but what I'm saying to you is, it helps you in understanding and answering your own questions for your own personal edification.
Okay.
And for you to move within this field, it's easier for you to refer back to these things and it makes your work so much easier.
Okay.
Because these cases now give you an understanding of what you're actually doing. So as much as the principle is derived from the case, just as you know okay, so I'm saying to you, his personal interests can conflict with his duties. Right?
Mm-hmm.
You should have evidence as to why that can't do it. You can't just tell me that you should give me some supporting evidence or something that backs up what you're saying.
Okay.
Because it shouldn't be just on your word that I count, eh?
Okay.
I need something to tell me that this is true. So I need a second opinion, more or less. So if you just tell me that as a client, no, he can't do that. They'll say, well, why he can't do that? And then you'll say, well, the law provides this, that. You'll go to either the trustee after, or you'll say cases have gone before the test. So this is only for you to even just do your own job. Because
Okay.
people are not going to rely on your word alone. You have to show them where you're getting this information from. So it helps you in your daily task in order to substantiate whatever you're saying.
Okay.
So you have case that went before that tells you where his duties can't conflict. What is that case? Y'all don't remember? What case tells you that a trust could be considered sham? Y'all remember that?
Yes, that's when the trustee, the settler is also a trustee.
What the case was? What was the famous case?
Oh, gee, you got it.
That's Raman's case. You all remember Raman? That's under sham trust.
Can't remember the name.
And the doctrine was now enunciated in Snook v. London and West Riding. You all remember Boardman and Phipps? No?
No, ma'am.
You just was going through, but really not looking at it like that.
For me, I wasn't. I was just reading and like, okay. And
What about
moving on.
McPhail and Dalton? What McPhail and Dalton? That's a basic case. What McPhail and Dalton deals with?
Mm-mm.
What? No?
No. No, ma'am.
What are the certainties of the trust?
Not from the beginning, but
No, y'all gotta know that. You all know the certainties?
Certainties of
Trip back.
intent, certainties of subject matter, and certainty of object.
Yeah.
Uncertainty of,
Subject matter, certainty of object, certainty of intention.
yes.
Right.
So what McPhail and Dalton tells us? Nobody? Y'all gotta go over these, okay?
yes.
That's only like this, like basic, like that's what Keisha Sanford says.
Is that what you're trying to do to us?
So Keisha Sanford tells us that a trustee must not allow his interests and duties to conflict.
What's the name? Quiche.
And Sanford, that's in your chapter. Let's see, y'all ran over these chapters without paying attention. That's unit 7. He can't take profits, that's Boardman and Phipps. Okay? Okay, let's get back to my chapter. I hope y'all don't forget my chapters like this. Y'all remember my chapter better than these other chapters say.
You making sure we know it. I like that though. You preparing us.
Yes, y'all have to
Like,
let this stick a little bit more.
I
okay?
realized that you asked us the same questions,
Uh-huh.
but in different ways, just to
Right.
ensure that we get it.
Yes,
Yeah, I
because
like
it
that.
could come anyway, you see, but
Right.
if I ask you, if you know it, I could
Mhm.
ask you anyway and you can answer it.
Right.
But that's the only way that means you comprehend.
Mm-hmm.
So I should be able to say anything, and because you know the basic foundation, the principle, you can answer any question I ask you. So if a client comes to you, whichever way they come, whatever situation they come in, you can answer it because you know the base, the foundation, and you
Right.
build on that, okay? So that's what these cases do. They give you the foundation and how it derives, and then that gives you an understanding. So most of these cases are what I call what Bahamians like gossip. So these cases are only gossip, you know, and if you are Bahamian, you like gossip. So if you read them, you find out what the people business was going on there. And then you say, oh, this what happened. Okay, so that's how they now say, well, this ain't got, because remember now, any cases that happen and they make a decision from it, it is to correct whatever went wrong and to tell you what not to do in the future and what to do in the future. So as much as it seems as if it's boring, if you take it from a concept of I'm reading somebody's information in the punch, then you would now get to understand your work a little differently because you're looking at it from a story perspective, not from a, oh Lord, I'm learning this foolishness.
But you know that is correct because to work this week we had 2 trust funds.
Mhm.
And the relationship manager, she was explaining to me what happened in both. So
Mhm,
we had one where someone died and left the trustee's wife,
mhm.
but he had children outside of his marriage,
Right,
and those children were included in the trust.
right.
So when he died, the wife, who was the sole beneficiary, she created another trust
Mhm.
for only her children. So like how you say, you're thinking about it as gossiping or
Yes.
really. And so I
Yes.
was like, so I was like, so why she do that? So what's going to happen to the other son and all that? And then
Right,
we were
She
talking about the
protecting our
different,
children.
right? And we were talking about like all of the documents that had to be done in order to,
right.
put
And
everything in
so,
perspective. So it
right,
made
and
sense.
from your class now, you'll be able to say, well, no, well, she can't do that because in accordance with this section of the trustee act, she have to do certain things, or does the trust clause, an instrument provide for that? And basically, no, she don't, that provision is in there because we have a case law that shows that the principle derives. So you see how it helps you with your own work.
It really did. And when she was talking about it, I was like, well, no, they should have done this. But what does the instrument say? And then the
Mhm.
relationship manager, she looked at me, she was like, you really reading it? I was like, not
Yeah.
really, but
Right, so you see,
things that I've
so,
learned come in together.
right, so now, so your learning now plays back into reality.
Yes.
And so it always marries and it incorporates. So once you get these basic principles, then you know you
Mhm.
can't do that because the law says this, and they have case law that established that why this thing has happened before, you can't do this again. So in Cowan and Scargill, we have some mind work, because so suppose you have you have a trust there that has invested in FTX. Yes.
Mhm.
However, the trust instrument provided that there should only be conservative investments.
Mhm.
What happens now? You know that you're in trouble, eh?
Right.
Because y'all were in breach. Y'all in breach of trust because what happened?
FTX is not conservative.
Right, and that means that you have not followed first of all, you've not held the standard of care
Mhm.
as set out in
The-
Spide and Gaunt.
Mm-mm.
Yes, Spide and Gaunt gives us the standard of care.
Oh, yes.
And then Cowan and Scargill gives us an example of where there is expressly stated in the trust instrument,
Mhm.
you can't now do what? You're in breach of trust if you fail to adopt the recommended investment strategy as set out in the trust instrument, because you could not do what?
You lose me there.
The primary duty of the trustees in deciding how and whether to invest the trust funds is for the benefit of the beneficiaries
Fisheries, right.
and the best interest of them. And as much as they may have highly social, political views or other views, they cannot do what? They can do that in the conduct of their own affairs, but they have to abstain from making such investments where they are not provided for in the
Trust instrument.
right. So they have to yield the best financial returns for the beneficiaries by way of income and capital. And they provide for those who are present and future, right? The trustee has to provide for the present beneficiaries.
And the future, yes.
And so in doing so, you have to follow what the trust instrument says, unless you have what kind of power you may have?
Discretionary.
Implicit.
Implicit
Oh,
power
implicit,
to do
uh-huh.
what? Unless you have an implicit power to do what? What you could do,
Give consent.
To vary.
right? Or you have a power holder or a protector you need powers of, where you have they have powers of investment, or you need consent to now invest. So if the protector told you invest in FTX, are you covered?
No. Yeah.
Yes, because
Yes, you're covered.
where there is a power of It is the
Consent.
power of investment given before I could, which requires the consent of a third party or where there's a power holder within the trust. So they've come to you to say, listen, you all invest in FTX. This trust said you all only should be invested in conservative investments. And now what happens? But there's a protector in this trust. Who has the power to give consent on investment? So what you gonna say as the trustee? Hello?
You would say as a trustee that you.
Okay, so let me give you the scenario again. We have a trust.
Mhm.
Not yet. We have a trust. We have a trust. Now, that has what? You listening?
Yes.
Anybody? Hello?
Yes, we listening.
Yes, yes, I'm listening.
Okay, we have a trust that is invested in FTX.
Mhm.
There's express clause that says you have to only invest in conservative investments. However, there's also a clause that gives the power to invest to the trustee with the consent of a third party. Who is the protector in this instance? So before I could have invested in FTX, I needed the consent of the protector. Now we know FTX has gone up in smoke. Is the trustee now in trouble?
No,
Why?
because he was told to do it.
So he was told, because you have to tell me a little better than that, so I'll know.
He got
He-
consent
he
from
felt
the
it,
third
yeah.
party.
Backed up.
Yes, consent of the third party, and in accordance with Rewise says that there could be, the
It
trustee
could be
can
allowed.
exercise the power of investment with the consent of,
Protector of a third party.
and where in section 18 of the trustee amendment act 2011 says where the trustee is acted on the instructions and directions of
The protector.
a
The
power
power
holder
holder.
or the protector, he is what?
Not held liable.
Right. See how you get tired of sparking and your answer could be like, this person know this whole story without any problem. So when you answering your questions, even within your workplace, you will say, well, as much as FTX failed, we're not in trouble because first of all, as much as there's an express clause that we shouldn't invest, the protector is well aware of that, or the settler was well aware. However, they had the power of investment, or they had to give us consent to invest. And as a result, we invested, and section 18 provides us with protection where section 18 of the Trustee Amendment Act 2011 says, well, there's a person holding a power. What happens? No, it's not section 18. Section 18 defines the power holder. Section 81A we talking about. What they say? Trustee may be absolved from any liability for loss to the trust where he has acted on the instructions or directions of a power holder or failed to act in the absence or direction from a power holder with responsibility for investment. Yes?
Right.
We clear?
Yes, much better.
Okay, good. Okay, who came in third? We did Alicia, we did Siobhan. Deandra. We'll now read Investments Power in the Bahamas Trustee Act 1998.
Section 4 of the Trustee Act 1998 gives trustees full powers of investing and of changing investments as any beneficial owner who is absolutely entitled, which will be exercised at the discretion of the trustees and in addition or subject to the provisions within the trust instrument. Section 5 of the Trustee Act 1998 gives the trustees guidance on the exercise of the power of investment and requires trustees to make, change, and retain investments as a prudent investor would, which narrows the general standard of care of a prudent man of business. In making investments, trustees should consider the following. 1, exercise reasonable care, caution, and skill that an ordinary person would. 2, have regard to the suitability of trust investments in the context of the whole of the trust property with a view to obtaining an overall balance of risk and return reasonably suited to the trust. 3, have regard to the need for diversification of investment so far as the trustees consider it appropriate to the trust. Section 5.2 outlines the considerations that the trustees must have in relation to deciding whether certain investments are appropriate for a particular trust, including the size of the trust property, general economic conditions, and the intentions and wishes of the settlor. Under Section 6 of the Act, trustees are not only empowered to select certain persons to provide investment advice and expertise to the trust provided that have the
Requisite.
Okay, bad, thanks. Knowledge, experience, and skill, but they may also be protected under law for any loss suffered by the trust in reliance on the advice of the selected investment advisor.
Okay, let's stop there for a minute. So Section 4 of the Trustee Act gives trustees full powers of investing and of changing investments as any beneficial owner who is absolutely entitled, which will be exercised at the discretion of the trustee and in addition are subject to the provisions within the trust instrument. So Section 4 comes into play if we don't have what? So where there's no mention of powers of investment, Section 4 kicks in, eh? We here today. If I don't have express powers of investment in my trust instrument, where would I look now to see what I can do?
Section 4.
Okay, you see?
Yeah.
So where you have now created, you have settled a trust, but then you realize, gee, I didn't put anything about investment. I don't have to worry because what Section 4 of the Trustee Act now comes into play. So it gives the trustees full powers of investing and of changing investments. And what we call that changing of investments, what that would have been in an express power of investment. That would have to be an investment clause, which gives us an implicit power to vary. Remember upstairs, we had an implicit power to vary. That would have had to be included if we wanted to vary what they set out first as a conservative trust. They may have given us implicit power that we could vary the trust investment portfolio at any time. But Section 4, if there's no provision of any of these things in there, Section 4 gives us the power to invest and to change investments as a beneficial owner who's absolutely entitled. And it's at our discretion. Y'all getting that?
Yeah, so I have a question. So in this instance, would they be liable to any loss, like saying that they go into the instrument now? It isn't where they have to go to a power holder or it's already in the trust instrument to what they have to follow.
Right, so now, what happens now? They are now held to a higher standard of care, right? When
Right.
it's come to investments, right?
Yeah,
What we say about them when they doing this? We come to them as a professional trustee, eh?
they have to be prudent.
Uh-huh. Because what we say, what they say,
That they're doing it to the best interest of for
for the
financially.
right?
Yeah,
So in this instance, you are held to a higher standard of care when you're doing these investments, because now there's no express powers of investment in the clause.
mm-hmm.
And we relying on section 4 of the trustee act because there was nothing there. So what they say in Spide and Gaunt,
That you have the standard of care.
so he's not allowed the same discretion in investing the monies of the trust as if he were a person sui juris dealing with his own estate.
Right.
Businessmen of prudence may and frequently do select investments which are more or less of a speculative character, but it is the duty of the trustee to confine himself. Well, in this case, we don't have a class of investments, so we won't worry about that because they don't have that. But he should avoid investments which are of a risky or speculative nature. He should ensure that he is protecting the financial interest, the best interest of the beneficiaries. And in this case, he is protecting what? What is the best interest of the beneficiaries?
The financial.
Yes, so you have to protect the financial interests of the beneficiaries. So he should not take unnecessary risk that would now jeopardize both income and who?
Capital.
Capital.
But let's
beneficiaries.
just say he doesn't take a risk, but one thing or another happens and like it crashed. Okay, let's take for instance, if we would look at Kanye West and
Mhm.
his incident where you would invest in his clothing line and what's not, but then he goes
He
out there
just
and
gone
make
off
this
the right.
erratic statement, and now he gone from a billionaire back to a millionaire in a matter of seconds.
Right,
Like you would think that would be a
that
good
was a
investment,
safe, right?
but he just made one wrong statement and that was the end of that. Nah,
Right.
everything
now-
fine.
So what we'll say now, what they said about that, when the trustee has done what he's supposed to do, is he liable? He's monitoring now. Remember, he has certain things to do. He has to, what we say earlier, in making investments, he should exercise reasonable care, caution, and skill, have regard to the suitability of the trust investment, have regard to the need for diversification, eh?
Right.
But then we have something else. What do you have to do? He has to supplement his standard of care. What he supplements it with? Once he's done these things, he's not in breach, eh? Because he's doing what he's supposed to do. He's taking.
Okay, got you.
So
Gotcha.
he's now he's not investing in risky or hazardous investments. So this is his duties. He can now invest. Section 4 tells us he can invest, eh? If there's no powers of investment expressed. But
Right.
then we have to supplement his standard of care. Remember that? where we must not invest in risky or hazardous investments unless it's expressly stated in the trust instrument. He must have full information about the investment. He has a higher standard of care where there's a professional carrying on business, providing advice and managing trust funds. The power of investment should do what? He should undertake to do periodic annual reviews.
Right.
And where the purpose is for financial assistance, he has to ensure that the best interest is for the best financial interest of the beneficiaries. So if he's supplementing his standard of care and he's doing what he's supposed to do under the standard of care, that is to act in the best interest and for the benefit of the trust, then he should be safe, eh?
Right.
Because he's monitoring things carefully. Now, there's no way he would be able to tell in one day this fellow would have messed up all those things, eh?
Yeah.
So he should not be held accountable in that instance once he's done what he was supposed to do,
Right.
okay? Because now you'll have to show that he's done all these things. He's done his periodic reviews, he's done this, but this is just something that happened out of the ordinary. This wasn't risky. We didn't take any unnecessary risks. We did what we were supposed to do, okay? Section 5 gives the trustee guidance on the exercise of the power investments, and it narrows the general standard of care of a prudent businessman in making investments. They should consider whether they consider the following. They should exercise reasonable care, caution, and skill that an ordinary person would. They should have regard to the suitability of the trust investments in the context of the whole of the trust property, with a view to obtaining overall balance of risk and return reasonably suited. So you think that was a balance when they would have invested in Kanye West's brand? Would that be balanced if they only had one investment?
No.
No, so they would have had to divest or diversify their portfolio, eh?
Right.
So you won't just be all invested in one thing. You would have to spread that investment over some investments. So we may have a little bit of this, a little bit of that. So you just can't throw all in one pot and say you've done your job.
Right.
So that's number 3 we come to, having regard to the need for diversification of investments so far as the trustees consider it appropriate to the trust. So we want to make sure we have income coming in. We want to generate income for the income beneficiaries, and we want to appreciate the capital for the capital beneficiaries. Section 5.2 outlines the considerations you must have in relation to deciding whether certain investments are appropriate for the trust. That is, what is the size of the trust property before I can do these investments? What are the general economic conditions and the intentions and wishes of the settler? When I'm making investments, I have to consider all those things. Is it now a good time for me to invest in cryptocurrency?
No.
No. And the trust property is only $1 million. Should I buy a condo they're selling in Exoma Keys for $750,000?
No.
Would that be beneficial to anyone?
No.
Because then you've now depleted the trust fund significantly, eh?
Right.
So you have to reach a balance. And then we have to look also at the intentions and wishes of the settler when he would have settled the trust.
Right.
So we'll need to see how we can diversify. So instead of me buying a $750,000 condo, I may say, let's look at something that would cost about $250,000. So I now have something for the capital beneficiaries. And then we can get some income from that. Or I may buy 2 for $500,000, and then we'll take the balance of the money, put some up on in government bonds, have some cash, and have some other stocks and in Apple or something area. I'll diversify now to bring as much return as I could to both income and capital beneficiaries. Under Section 6 of the Act, trustees are not only empowered to select certain persons to provide investment advice and expertise They must have the requisite knowledge and skill, but they may also be protected under law for any loss suffered by the trust and reliance of the advice of the selected investor. So they can now select an investment advisor, and based on the advice they would have received, provided they've done all of their due diligence, they will now be protected from any loss suffered to the trust. So you see where Section 6 would now cover them for loss suffered by the trust had they done what they were supposed to do as outlined in Section 5 on the guidance and exercise of their power of investment. So you see how it marries back? The question was, what if they had lost, what would happen? Who asked the question?
That was me.
Okay, so now you see Section 6,
Mm-hmm.
you now answer your question with Section 6.
Got you.
You see, Section 6 now says, once they've done all these things they were supposed to do, they're covered. So Section 6 says, they'll be protected under the law for any loss suffered by the trust, reliance of the advice of a selected investment advisor. They use a selected investment advisor because what they did, they went under Section 5 for guidance on the exercise of their power of investment. They considered all of these, taking the exercise in the reasonable care and skill, having regard to the suitability, having regard for the need for diversification. And where Section 4 gave them full powers of investment, they did all those things, and now they're covered under Section 6 because they would have done all they had to do as a trustee under their duties.
Got
Any
you.
question? No? Okay, so who's gonna take us? Who's the last one? Lavette, you can help us with the last ones.
Okay, that's from similarly.
Similarly, yes.
Okay. Similarly, Section 13 of the Trustee Amendment Act 2011 allows a trustee the protection of law for any liability or loss occasioned by the trust, where such trustee has acted on the instructions or directions of a power holder or failed to act in the absence of a direction from a power holder with responsibility for investment.
Okay, so you see how your section, Unit 2 now is in Unit 11? So you
Yes.
see there's a lot of repetition, so y'all should not forget it, eh? And what Section 13 does?
Allows a trustee the protection of law for
So
any
section-
liability or
Right,
law.
and what that inserted, what's in there? It inserts section what into the Trustee Act 1998?
81A.
Yeah, so 81A. So you could just put on the side of there, 81A Trustee Act 1998. Because this is what this does, Section 13 inserts 81A into the Trustee Act 1998, and it says that you're protected from any loss occasion when you acted on the instructions or directed, or when you fail to act in the direction, in the absence of direction. Okay? Go ahead.
Okay. With regard the legal protections under the law, a trustee will only be afforded such protections if they have properly discharged their obligations with regard to their selection or appointment of the investment advisor and the continuing supervision of such advisors to ensure that such agents act in accordance with the provisions of the trust and with the same objective of preserving and protecting trust property from needless loss. Once the trustee properly appoints and supervises the agents to whom he may delegate investment tasks, he may seek protection against liability for loss suffered by the trust due to actions of these third parties.
Okay, so once he's done what he's supposed to do, he's not only selected and the investment advisor and delegated his powers to him, he has to continually supervise the advisors to ensure that they're acting in accordance with the provisions of the trust and with the same objective of preserving and protecting the trust property from needless loss. So once he's done this properly, and he supervises his agents to whom he delegates these tasks, he can seek protection from liability for loss suffered from the trust due to actions of these third parties. Okay? Go ahead.
Implicit in discharging their investment powers within the trust instrument or under the act, a trustee must ensure that proper investment objectives are made and an investment strategy is created to invest trust property for the specific trust that he is administering. This is often done by the trust committee for a professional trustee.
So remember, we talk about the trust committee because this decision isn't made by one person. We have a trust committee where we may have some persons on it to assist us in making our investment decisions. Okay, go ahead.
Okay. Once the investment strategy has been created and executed, the trustee must ensure that there are periodic reviews of the investments and the investment strategy in order to detect any changes in such investments which may cause loss.
So we gotta periodically review what we're doing. So we can set periodic reviews to be at least annually, or we can do it even in a shorter period. Who tells us about that? What case tells us about that? These periodic reviews we should have. Nestle, you all remember that?
Yes.
That's Nestle and National Westminster, I think it is.
Yes, review should take place at least annually, but we could do it even quicker, eh? So you see, it's a
Yeah.
repetition. What, just so we can put on the side of what was said above. Where they said the trust will not could seek protection against liability for loss suffered by the trust. What section deals with this?
13.
Say it again?
13.
No, would we, section 6 of the what?
Trustee Act 1998.
Yes. So they reiterated what we already read. Okay. Okay, go ahead.
The trust administrator should ensure that he reviews and inspects the brokerage statements on a regular basis and provide the trustee or trust committee with the information regarding the particular investments, the terms of the trust instrument relating to investments and investment powers generally. Pertinent information on the beneficiaries regarding their circumstances and any advice or recommendations by the investment advisor.
Okay, so you should ensure he reviews and inspect the brokerage statements on a regular basis. Provide the trust or trust committee with information regarding the investments. Give them the terms of trust relating to the investment powers generally, and pertinent information on the beneficiaries regarding their circumstances, any advice, and what is it? Any advice or recommendations by the investment advisor. We'll tie that section back to. Supplementing a standard of care, the supplement to the standard of care, remember that? On the second page, I don't want to hold no page because you all have a different page to be on the trustees' investment duties. Do you see that? 1 to 5.
Yes, page 86.
Yes, so you see it's the same thing, just in a little summary. So we go right back to what we calling this here? What we calling this section, the supplement? This is supplement to the standard of care, right?
Yes.
This is supplement to the standard of care established in the case of,
Not.
starts with an S.
Site versus gone.
Yes, we can get this in y'all before the time over. Right?
Thank you.
Yes, okay. Let's answer some questions. Any questions before we start our questions? Nope, okay.
Yeah.
Number one, trustees invest trust funds in order to provide and blank for the income beneficiaries or blank for capital beneficiaries. Where we'll find that answer.
Page 85.
Page 85, and what is that?
Income capital. That's
Okay.
paragraph 1.
Okay, excellent. The trust instrument often provides blank to the trustees. What is that? Where we'll find that answer. Right underneath the first answer. Same page.
Trust instruments provide express powers.
Of investment.
Okay,
Y'all see it?
yeah.
Everyone got it?
On page 85, the second
Line of the
Yeah.
first paragraph. The primary duty of the trustees in deciding how and whether to invest trust fund is to blank and in the best interest of the trust. Where will you find that answer? We just read this thing back and front. You should know. Just will know. This at the bottom of your page 85 and the beginning of the next page. It's 74 for me. I have an old book. Bottom of 74 and beginning of 75.
is to invest trust funds and to act in the best interest of the trust.
To act for the benefit of the beneficiaries and in the best interest of the trust.
Can you repeat that for me, please?
Right on the bottom of the page, they are the primary duty of the trustees in deciding how and whether to invest trust fund is to act for the benefit of the beneficiaries and in the best interest of the trust. Both present and future, all of that stuff. You all saw that?
Right.
What are the general investment duties of trustees? We will find that. What page?
86.
And what that is? Numbers 1 through
5.
1 through 5. They can invest in risky or hazard investments unless expressly provided. They must have full information about an investment before they make it. They owe a higher standard of care where it is a professional trustee carrying on business of providing advice. They should take periodic reviews as with a power of investment over the investments held in the trust. And where the purpose is to provide for financial assistance of the beneficiaries. The beneficiary's best interest is usually their, what is the beneficiary's best interest?
Financial interest.
Their best financial interest. And where moral considerations do not affect the financial interests of the beneficiaries, they can be taken into consideration. What is the standard of care required under Section 5 of the Trustee Act 1998? Where we'll find that answer?
87.
87, and what is that? What's the standard of care? In exercising his power of investment, what he has to do? Make, change, and retain investments as a prudent investor would, which narrows the general standard of care of a prudent man of business.
Okay.
Y'all see that?
Yes. Yes, it is again.
That's where you'll have the regard for the need to diversify the investment, suitability of the trust investments in the context of the whole of the trust property, with a view to obtaining overall balance of risk and return. Would we use this example where we had $1 million? What we did? What we did with our $1 million? Did we buy all one thing?
No.
No,
No.
yeah, we diversified it.
Right, so we have to have regard to and then we have to decide what we're gonna buy. Is it suitable for us to make sure that the income and capital beneficiaries are able to realize returns on their money? Okay, we're gonna exercise the basic reasonable care and skill as an ordinary man would, but we have to do a bit more, right? You have to make, change, and retain investments as a prudent investor would. So we have to now step up a bit. We now as a prudent investor. Number 8, Section 13 of the blank allows a trustee the protection of law for any liability for loss occasioned by the trust, where such trustee has acted on the instructions or directions of a power holder or failed to act in the absence of a direction from a power holder with responsibility for investment.
Trustee Amendment Act.
Trustee Amendment Act 2011.
2011, okay.
Which inserts
Trustee.
would we insert in there? 81A into the
81A.
into the Trustee Act 1998, remember?
Right, okay.
Number 9, with regard to the legal protections under the law, trustee will only be afforded such protections if they have properly discharged their obligations with regard to their blank of the investment advisor and the blank of such advisors to ensure that such agents act in accordance with the provisions of the trust and with the same objective of preserving and protecting trust property from needless loss.
With their regard to their selection or appointment of the investment
And
the continuing supervision
where we'll find that answer?
on page 88.
88. Everyone sees it?
Which paragraph?
That's the second paragraph, right?
Well, yeah.
Mhm. Number 10, once the investment strategy has been created and executed, the trustee must ensure that there are blank of the investments and the investment strategy in order to detect any changes in such investments which may cause loss.
Periodic reviews.
Periodic reviews. Where we'll find that answer?
1, 2, 4th paragraph.
Okay. Everyone got that? Okay, I don't know if we want to try to begin section, unit 12, because if we could read through unit 12, then we could just read unit 12, we all have a couple minutes. So we can go over that next week, and then we could just start unit 13. What you think? Because we only have one more class.
Or we can, or
So
we,
we have a unit 14, Ms. Dawson?
no,
No unit 14,
Oh, okay, so 13 is the last.
right?
or we
But I
can,
think, let's see how big 13 is.
or
I
we
think
could
we should
read
give
unit
ourselves
12.
a little advantage of reading at least 2 pages, eh? What you think?
Yeah, let's try finish 12. And
Yeah,
then
Finish.
next class, we could do 13 and we could recap.
right.
Because for me, I'm normally not this unprepared, but I've been on a roller coaster with this flu for like 3 weeks now.
Oh,
So
Okay, oh yeah.
yeah, I have a lot of catching up to do.
Okay, but I mean, it's helping y'all with us going over it, eh?
Yes, it does.
Okay, good. Okay, so now in unit 12, we should be able to understand beneficiaries' interest in the trust, understand the trustees' duties to beneficiaries, and understand the rights of beneficiaries in relation to the administration of the trust. Okay, Lavette, you can start us off.
Okay. After completing this unit, students should be able to 1, understand beneficiaries' interest in a trust. 2, understand the trustees' duties to beneficiaries. 3, understand the rights of beneficiaries in relation to the administration of the trust. A trustee has a duty to act in the best of interests of the beneficiaries of a trust. Failure to act in the best interests of the beneficiaries would result in a potential breach of trust. Action against the trustees by the beneficiaries. A trustee must treat all beneficiaries fairly and impartially, and must balance the interests of the income and capital beneficiaries of a trust to ensure that all the needs of the beneficiaries are met efficiently and effectively in the administration of the trust. Additionally, trustees must not put their personal interests in conflict with their duties to the beneficiaries or before the interests of the beneficiaries, as it would be a breach of their fiduciary duty. Cohen versus Scargill, 1985. In Cohen versus Scargill, it was decided that the duty of the trustees towards their beneficiaries is paramount. They must, of course, obey the law, but subject to that, they must put the interests of beneficiaries first. When the purpose of the trust is to provide financial benefits for the beneficiaries, as is usually the case, the best interests of the beneficiaries are normally their best financial interests. Beneficiaries have a vested interest in the trust property as equitable owners. Their equitable interests must be preserved and protected by the trustees in the effective and reasonable administration of the trust.
Okay, so the trustee has to act in the best interest of the beneficiaries of a trust. Where they fail to do so, it may result in potential breach of trust action against the trustees by the beneficiaries. He must treat all the beneficiaries fairly and impartially and must balance their interests. That means both the income and capital beneficiaries to ensure that all their needs are met efficiently and effectively in the administration of trust. What do we say about that? We have to ensure that when we get this $1 million, what's gonna happen?
It's distributed.
We diversify the portfolio sufficiently that we appreciate the capital. That means we take the capital to keep going up. So we start off with $1 million, and by time as we finish diversifying the portfolio, the capital is now at $2 million. Yes. And the income beneficiaries get at least $20,000, $40,000, $50,000 a quarter. from the income. Yes? So we are now looking out for the best interest of the income and capital beneficiaries with how we've invested the trust funds, yes? We
Yes.
cannot put the personal interests, our personal interests, we can't conflict it with our duties to the beneficiaries or to put our interests before their interests, as it would be a breach of fiduciary duty. And who tells us about this? Which case?
Coleman versus Cargill.
Right. And what Cohen and Scargill was about? What that case was about?
Beneficiaries.
Right. What happened in Cohen and Scargill?
So currently one didn't operate one didn't operate with putting the beneficiaries first.
Right, but what happened in that? What that
Financial
case was
benefit.
about?
Financial benefits.
No, we read that in the last chapter. What Cohen and Scargill was about, anyone?
My bad.
Coal miners, you all remember that?
Oh, that with the pension, the fund.
Right, so these were coal miners. And they had a non-compete clause in their thing that investment shouldn't compete with their interest. Remember that? They were in coal and the trustees decided to do what? Invest in what?
Yes.
In
Another
energy.
company
In energy.
Energy.
That's
Right.
a competition.
Right.
in the
So
French
that-
coal mining. Yeah.
Right, so now they have a duty towards the beneficiary. Their duty is paramount, eh? They must obey the law, but they must put the interests of the beneficiaries first. And if the purpose of the trust is to provide financial benefits for the beneficiary, what is the best interest of the beneficiary?
Financial interest.
Yes, their best financial interests. So the beneficiaries have a vested interest in the trust as equitable owners. That means what? What are you as an equitable owner?
Money.
Hmm?
Money.
So what's the difference with me being a legal owner and an equitable owner?
Legal would just be more like entitled to the capital.
You all start this off with who's the legal and
That's a
equitable?
settle. It's the legal
The
interest, right?
legal is the trustee.
Right, so the
Right,
trustee
the
now is
trustee.
the legal owner,
Beneficiary.
and he's holding it for the benefit of the equitable owners who are,
The beneficiaries.
right, because legally, if they look at the documents, they'll say, well, really and truly, who's the legal owner of this house? Let's use Butterfield Trustees Limited.
Mhm.
They're the legal owners, eh? On the face of it, if you come to me and they said, this building, I just slipped down in this, and I see the name on here, who's the legal owner?
But if you be the legal owner.
That's their
Butterfield
property.
Trust.
Right. Right.
Yeah, Butterfield Trust is the legal owner. But
Right.
Butterfield Trust is only holding this for the equitable owner, eh?
Right.
They're holding it in trust for the equitable owner, who is the what?
Beneficiary.
Yes. Okay. So the beneficiaries have a vested interest as equitable owners. And their interests must be preserved and protected by the trustees in the effective and responsible administration of the trust, okay? Okay, let's go on to beneficiaries' rights.
You want me to finish it or
Yes,
somebody
please.
do?
You could just finish this page and then we'll go on to, we going backward now. Who was next? Yeah, DeAndre after you.
Okay, beneficiaries' rights. As a beneficiary, he has certain rights under law in relation to the trust and trustees administration. Both statutory and common law require that the beneficiary has the right to information regarding the trust, except information that may be prohibited by law.
Now, what section of the Trustee Act gives us the right to information? as a beneficiary?
Section of information,
Mhm.
83.
Okay, good stuff. Okay, go ahead.
The trustee has a duty to give the beneficiaries information regarding the state of affairs of the trust. In the case of Oruki
O'Rourke versus Derbyshire.
or versus Derbyshire, 1920, Lord Renbury stated that a beneficiary has a right of access to the documents which he desires to inspect upon what he has been called in the judgment, in this case, a proprietary right. The beneficiary is entitled to see all trust documents because they are documents and because he is a beneficiary. They are, in this sense, his own.
Mm-hmm.
You can say.
Oh, you've
Deandra
moved
next.
on. You've moved on. It's Deandra now.
Yes.
Mhm.
However, a beneficiary is not entitled to see all documents belonging to the trust, as minutes of meetings and correspondences between trustees are not permitted to be seen by the beneficiaries, particularly those which indicate the exercise the trustees' discretionary powers in the administration of the trust. For the purposes of trust law, these documents do not form part of trust property for which beneficiaries have an equitable interest and a proprietary right.
So the beneficiary is entitled to see all trust documents because the documents are his own. He's a beneficiary, eh?
Yes.
So in order to avoid the trustee being compromised or sued because he's used his discretionary powers, certain documents do not form a part of the trust documents, right? And they are minutes of meetings, correspondences between trustees, and the like. They're not a part of the trust documents. So he cannot request documents that are not a part of the trust documents, are they? So if he's asked to see all documents belonging to the trust, these are not documents belonging to the trust. They are belonging to now the trustee. Because he's exercising what in this instance?
Right of information.
He's exercising discretionary powers
Oh, okay. Okay.
in administering the trust. So they don't form a part of the trust. They are what he's using to now make decisions on the trust. So you may have a working file and you may have a trust file. That way you would separate the trust documents from the documents that the beneficiaries are not entitled to see. So what we may have in the trust documents. Trust instrument, some accounts.
Right, the statements.
Mhm.
But they're not entitled to, I think it's the resolutions or the meetings.
So would we put the minutes in there?
No,
Would we put correspondence in there?
no,
Would we put the letter of wishes in there?
no.
Okay. So we are clear.
Yeah.
So for the purposes of trust law, these documents do not form a part of trust property for which the beneficiaries have an equitable interest or a proprietary right. Okay, go ahead.
An important reason for this prohibition is that
Prohibition.
to
Okay.
allow beneficiaries to have access to such documents may create a challenge to the exercise of the trustee's discretion. However, a beneficiary is entitled to see the title deeds, accounts, and other documents relating to the trust. In Londonderry Settlement, 1965, the trustees of the settlement had a power exercisable with the consent of certain appointers to appoint shares of capital amongst a class of beneficiaries. A member of the class was dissatisfied with the share appointed to her and was of the view that she was entitled to inspect the agenda, minutes of trustees' meetings, and correspondence of the trustees. The court held that the beneficiary was not entitled to inspect the documents. In accordance with the law established in Londonderry settlement, a beneficiary has to show the following in order to be entitled to inspect any documents in possession of the trustees. 1, they were documents in possession of the trustees as trustees. 2, they contained information about the trust which the beneficiaries were entitled to know. And 3, they had a proprietary interest in the documents.
Okay, so they prohibit the beneficiaries to have access to such documents because it will now challenge the trustees in exercising his discretion. He's entitled as a beneficiary to see title deeds, accounts, and other documents relating to the trust. However, in Londonderry settlement, we had the trustees where they had a power to appoint, with the consent of certain appointers, to appoint shares amongst a class of beneficiaries. Where the member was dissatisfied with a share appointed to her, she wanted to see and inspect the agenda of the meeting, the minutes the trustees would have taken at the meeting, and the correspondence of the trustees. The court held that she was not entitled to inspect the documents. So they're saying the law has been established that in accordance with Londonderry's settlement, a beneficiary has to show the following in order to inspect any document in the possession of the trustee. He has to show that the documents were in possession of the trustees as trustee. They contain information about the trust which the beneficiaries were entitled to know, and they had a proprietary interest in the documents. So you have to show those things as a beneficiary in order for you to inspect the documents. And the law has prohibited you from looking at the trustees' minutes and correspondence, where they're exercising their discretion. Go ahead.
Section 83 of the Trustee Act 1998 gives beneficiaries of Bahamian Trust the right to information under certain specified conditions and in certain specified circumstances. One such right is the right to information regarding the production and receipt of trust accounts as and when requested by the beneficiaries.
So they have a right to trust accounts, yes? When
Yes.
you request them.
Beneficiaries have a right to inspect trust accounts and demand information and explanations on them. Under common law, beneficiaries are not entitled to demand copies of trust accounts unless they are prepared to pay for them. Read Watson.
We talked about that last week. You go into the bank for your statement, you have to pay for it,
Yes.
And you can sit down with your banker and ask them to explain why this amount was here, why this, you can go through that, Isn't that basic what happens? Sometimes you may have questions on your accounts.
Under Section 83 of the Trustee Act, beneficiaries are not allowed to obtain information regarding trustees' deliberations in relation to distributions to them. Therefore, beneficiaries cannot demand documents such as minutes of meetings and correspondence between the trustees, particularly those which may specify the trustee's reasons for the exercise or non-exercise of his discretion in a discretionary trust.
So the trustee don't have to give you any information on their deliberations or their meetings or correspondence dealing with how they made their decisions in a discretionary trust. That's not a document that forms a part of the trust or which you are entitled to as a beneficiary. Any questions?
No, ma'am.
Okay, we have, go back to Alicia, I think. Who
Okay.
started out? Yes, go ahead.
However, the trustee's duty to disclose information and the beneficiary's right to trust information are the subject of the decision in the case of Vadam Schmidt versus Rosewood Trust Limited, 2003 to AC 709, the Schmitz case. In the Schmitz case, Mr. Vadim Schmidt sought disclosure of accounts and information in relation to two trusts set up by his father, who had died in the state. Rosewood Trustee Limited was the trustee of the two relevant trusts, having assumed that office from Lorne House Trust Limited, the original trustee. Mrs. Schmidt had a discretionary interest under the settlement and saw disclosure in his capacity as a beneficiary, as well as in his capacity as the administrator of his father's estate. The trustee argued that Schmidt was not entitled to disclosure of the trust documents because he did not have a proprietary interest under the trust, being only a mere object of a power. Also, the trustee argued, had the father been the settlor under the trust, which had been executed by Park Correct Limited as settlor, the nominee of Mr. Schmidt. The court held that the beneficiary's right to information was not only reliant upon the trustee's fiduciary duty to keep them informed regarding the provisions and administration of the trust generally, but also upon the court's inherent jurisdiction to ensure that the trust is administered in accordance with the terms of the trust, and if necessary, act on behalf of the beneficiaries to achieve this objective. Therefore, the classification of a document as a trust document, the beneficiaries' interests and their ownership rights to trust assets were not the primary considerations in determining the beneficiary's right to information. Based on the Schmidt's decision, a document will be ordered to be disclosed if it would conducive to the proper administration of the trust. It does not matter whether the document is classified as a trust document. Requests from beneficiaries must be reviewed on a case-by-case basis, and trustees should be guided by the purpose for the beneficiary's request and the interests of the beneficiary. Following the decision of the Schmitz case, a trustee should take into consideration the following information when making a decision to disclose trust information to beneficiaries. A, the nature of the request. B, the reasons for the request. C, the information being requested. And D, the sensitive nature of the information being requested. Additionally, the trustee may refuse to accede to a beneficiary's request for information Additionally, the trustee may refuse to accede to a beneficiary's request for information if there are. Okay, thank you. If there are legal grounds to do so. Example, information is privileged. The information is confidential as per one beneficiary to another beneficiary. The interest in the trust is a remote or contingent one. The information may be prejudicial or adverse to the trust. Example, challenge to the validity of the trust, and the disclosure of the information may be too costly for to the trust.
Okay, so we have the Schmidt case, yes?
Yeah.
So we have the trustee's duty to disclose information and the beneficiary's right to trust information are subject to the decision in this case. In this case, Mr. Smith saw a disclosure of accounts and information in relation to two trusts set up by his father who had died intestate. So his father died without a will. Rosewood Trustee was the trustee of the two trusts, having assumed the office from Lawn House Trust Limited, who was the original trustee. Mr. Smith had a discretionary interest under the settlement. When you have a discretionary interest, what that means? When you have a discretionary interest.
That you're able to make decisions based on, I guess, the trust instrument or what you think would be in the best interest of the trust.
So this is where McPhail and Dalton talk about discretionary trusts, yes?
Right.
So if you have a discretionary interest, you're a beneficiary of a discretionary interest. That means it's for the trustee to decide in their
Right.
discretion whether they're gonna give you something, right?
Right.
So
That's why
he
they
have
go to
a,
the trust committee, right?
Hmm?
The discretionary, they would have the trust committee, I think that's what it's called. Who would make the decisions and the discretionary?
The discretionary interest means that you are only a discretionary beneficiary. So it's up to the trustee to decide whether or not they're gonna give you income. It's up to them, more or
Right.
less. Unlike when you have a proprietary interest, which you have as a proprietary interest. You have a right. You have interest, you have a vested interest, you are proprietary, you have a proprietary beneficiary. So you have a right to certain things, you are more or less vested in the trust. So the trustee don't have a discretion as to give you, it is innate that they have to give you something. It's set out clearly that you should get this, you should get that. Okay, that's the difference there. So he, as a discretionary, he had a discretionary interest under the settlement and sought disclosure in his capacity as a beneficiary, as well as in his capacity as the administrator of his father's estate. Now he assumed the role of administrator because remember his dad died without a will.
Right.
So now the trustee argued that Smith was not entitled to disclosure of the trust documents because he did not have a proprietary interest under the trust. What we said earlier about that, but the proprietary interest. Remember they say, in the sense it is his own because he have a proprietary right. A beneficiary has a right of access to documents which he desires to inspect upon what he has been called in the judgments, in this case, a proprietary right. That's in O'Rourke v. Derbyshire. Remember that upstairs? For the purposes of trust law, these documents do not form a part of the trust property for which the beneficiaries have an equitable interest and a proprietary right. So where they have proprietary right, Londonderry settlement says a beneficiary has to show the following in order to be entitled to inspect any document in possession of the trustees. What they say he have to have? What's the last thing he has to have?
The proprietary
Interest.
interest.
You see that? So now the trustee is using that to say he don't even have a proprietary interest under the trust. He's only a mere object of a power. So he's only a mere object. At any point, I can decide whether or not I'm going to give him anything. I have a discretionary power, and he's only an object of that power. Who are objects of the trust? What is an object of the trust?
The beneficiary
No, but beneficiary
is
is the object, sorry, is the object of the trust. What's the subject?
the subject matter would be like the properties and what's not like
So
the
he's
payments.
only a mere object, meaning he's only a
Beneficiary.
discretionary beneficiary.
Beneficiary. Okay.
Okay. So the trustee argued that the father had been settled under the trust, which had been executed by Parkeret Limited as settler, the nominee of Mr. Smith. The court held that the beneficiary's right to information was not only relying upon the trustee's fiduciary duty to keep them informed regarding the provisions and administration of the trust generally, but also upon the court's inherent jurisdiction to ensure that the trust is administered in accordance with the terms of the trust, and if necessary, act on behalf of all beneficiaries to obtain this objective. So what are they saying in this instance? As much as he doesn't have a proprietary interest in the trust, what he has?
Beneficial interest.
They have
Where?
this information contained about the trust, which the beneficiaries are entitled to know in order to ensure, so the court's inherent jurisdiction will now step in to ensure that the trust is being administered in accordance with the terms of the trust, and if necessary, to act on behalf of the beneficiaries to obtain this objective. What happened? Why the court would rule like this? Because what happened? This trust was set up by, these two trusts were set up by the father. He died intestate.
Mhm.
Rosewood was the trustee of the two trusts. They assumed office from another trustee, who was the original trustee, you see?
Right.
So now the original trustee is no more acting. We have some new trustees in place. So Mr. Smith, under his discretion, as a discretionary beneficiary of both of the trusts, and as the administrator of his father's estate, is asking for some information. But the trustees say you are not entitled to this information. You only a mere object of a power. You don't have a propriety interest. But he's saying, no, I am entitled to ensure that this trust is being properly administered. Yes? So the court used the inherent jurisdiction to say what? They want to ensure that the trust is administered in accordance with the terms of the trust, and it's necessary to act on behalf of the beneficiaries to obtain this objective. So not only one set of beneficiaries, but all, eh? Yes? You're still with me?
We
still there.
Okay,
taking it all in.
so now the classification of a trust document, the beneficiary's interest and their ownership rights to trust assets were not the primary considerations in determining the beneficiary's right to information. Based on this decision in Smith, a document will be ordered to be disclosed if it would be conducive to the proper administration of the trust. It does not matter whether the document is classified as a trust document. Yes? Requests from beneficiaries must be reviewed on a case-by-case basis. So it's not carte blanche, you just put a general swipe over the thing. And the trustee should be guided by the purpose for the beneficiary's request and the interest of the beneficiary. So what is the purpose of your request and what is the interest? So you considering all these things going forward. So the case of Smith tells us now that when the trustee should take into consideration the following information when making the decision to disclose trust information to beneficiaries. What is the nature of the request? Why are you requesting this? What you asking about this document for? What is the reason? What is the nature of the request and what is the reason why you're asking it? What is the information that's being requested and how sensitive is the nature of the information being requested? The trustee may then refuse to accede to a beneficiary's request for information if there are legal grounds to do so. Example, the information is privileged. That's something I can't disclose because that's privilege between us to me and the trust. The information is confidential as from one beneficiary to the other. So the settler may have said this beneficiary should get more and this one should get less. That's nothing to be disclosed to the other beneficiary, right? The interest in the trust is a remote or contingent one. So your interest in this trust is so remote or it's contingent upon an event happening. On legal grounds, I don't think I need to disclose information to you because you so far down the line, you're so remote from ever getting any part of this trust. It's not for me to disclose any information to you now because we have to go through three generations before you ever get anything, or it's contingent upon 1, 2, and 3 persons dying before you get it, or you may have to attain the age of 35, and based on the way you're traveling, I don't know that you're going to make it. The information may be prejudicial or adverse to the trust. Example, it may challenge the validity of the trust. So it may be prejudicial to the trust, meaning that we may be benefiting someone that if this information gets back to their country, it now can challenge the validity of the trust. They may sue the trust because this person who's requesting information may make that information available to certain authorities that may now cause a problem to the trust being valid. They'll say, well, this beneficiary is not disclosed to us, this or the other thing, or it shouldn't be that this may be enforced heirship jurisdictions where, no, you couldn't just pass this on to your children. They have to go through the proper laws and stuff. So now it will now bring a challenge to the trust validity. And the disclosure of the information may be too costly to the trust. For me to get all this information to you, it'll cost us an arm and a leg, or it may cost us in reputation or otherwise. So I'm not, on legal grounds, we refuse to do so. And now you'll take us to court and the court will make a determination as to whether we made the right decision. Any questions?
No, ma'am.
So Smith tells us as much as O'Rourke and Derbyshire says that the trust, well, Londonderry settlement says that these people may be able to inspect the trust documents, only these people. And O'Rourke and Derbyshire says what? What they say? Would they say a beneficiary has right to access if you have a proprietary right?
Mhm.
And the law says certain documents do not form a part of the trust. Smith says you must consider the nature of the request, the reasons for the request, the
Right.
information being requested, and the sensitive nature. And you may refuse on legal grounds based on the information being privileged, confidential. Is the interest requesting the information is a remote or contingent one. The information may be prejudicial or adverse to the trust, or the disclosure of the information may be too costly to the trust.
Right.
Okay? Any questions?
Very good.
Okay, so now we will finish off. You finish this last sentence, this last
Okay.
paragraph, and then it'll be, who else is reading next? Siobhan. Okay, go
Okay.
ahead.
Additionally, beneficiaries have the sole and exclusive right to sue trustees in relation to a breach of trust or any other legal action regarding the administration of trust and their duties and obligations to them. It should be noted that Section 23 of the Trustees Act 1998 does allow trustees to insure themselves from the trust fund for legal actions brought against them by beneficiaries except for breach of trust.
Okay. So the trustee can now insure themselves?
Right. It's
Now that's
liability
not-
insurance.
No, that's section 24, I think it is, not 23. I don't know why that's still in there unless we have Trustee Act 1998. I think it's section 24. Let's make sure. Trustees may insure. Section 24, 23 deals with, let's see what 23 deals with. 23 deals with the evolution of powers of trustees. So it's section 24, not 23, okay? Okay, go
All
ahead,
right.
Siobhan. So when the trustee has to go to court now, when the beneficiaries take them to court, they have insurance, eh? Yes,
That's correct.
they can insure against certain actions, and who would be responsible to pay for this insurance?
The trustee,
The trust,
the trust.
yes,
Okay.
okay, go ahead. The responsibility is set out in section 24. They have the power to insure themselves
Right.
out of the trust
Okay.
fund.
Let me
Okay?
continue until Siobhan comes back.
Okay, go ahead.
Beneficiaries also have the right to terminate a trust through the use of the rule in Saunders versus Warrior. In the circumstance where a trustee holds property in a trust for one beneficiary and there are no contrary terms in the trust instrument, that beneficiary, if he is sui juris of the requisite mental and legal capacity, has the right to request that the legal title to the property be transferred to him, for which the trustee is obliged to do. Both the legal and equitable interest in the property will be vested in the sole beneficiary, and the trust will effectively terminate. When there is more than one beneficiary, in order for the rule of Saunders versus Fortier to apply, all of the beneficiaries must be sui juris and properly ascertained and complete as a group, and beneficially entitled to the trust property. The rule in Saunders 48 versus 48 cannot apply in the case of unborn, unascertained, or unascertainable beneficiaries. However, the rights of beneficiaries in relation to the rule in Saunders versus 48 may be restricted depending upon the circumstances. While the rule in Saunders versus 48 enables beneficiaries to end a trust in certain specified conditions, a settlor may expressly exclude this rule by placing an express clause within the trust that the beneficiary shall not be able to end the trust by collectively requesting the legal title to trust property. Additionally, trustees must control the administration and management of the trust. Beneficiaries, whilst they may have an equitable interest in trust properties, are not entitled to dictate to the trustees how they should exercise the powers and discretions contained in the trust instrument, re Brockbank 1948. The common law principle allows the trust to run smoothly, free of any interferences from the beneficiaries, particularly those who may seek to advance their own interests at the expense of the other beneficiaries, and possibly wield some inappropriate influence over the trustees, who may not be mindful of their legal and fiduciary duties to the trust and the beneficiaries generally.
Okay, so the rule in Saunders v. Fortier says what? The beneficiaries have the right to terminate the trust?
Right.
Where, what?
In the
Where the
circumstance
trustee-
where a trustee holds property in a trust for one beneficiary, and there are no contrary terms in the trust instrument, then
The beneficiary who is?
sui juris
Mm-hmm.
has the right to request that the legal title to the property be transferred to him, for which the trustee is obliged to do.
So then both the legal and equitable interest in the property will now be vested in the sole beneficiary, and the trust will immediately or effectively terminate.
Right.
Where there's more than one beneficiary, in order for the rule in Saunders and Fortier to apply, what has to happen?
All beneficiaries must be sui juris and properly ascertained and complete as a group, and beneficially entitled to the trust property.
Okay. And the rule in Saunders and Fortier cannot apply in the case of?
Unborn, unascertained, or unascertainable beneficiaries. What does that mean, please?
So if what we said about certainty, so that now falls into certainty of one of the three certainties. What is that? Certainty of what? Where you have unascertainable beneficiaries. You can't ascertain, right, objects. So unascertained means we have not ascertained these beneficiaries in this class yet. We've not been able to determine who the beneficiaries are. You said all of my children or all of my grandchildren, they've not been properly ascertained, or all of my employees. In the case of a company that you can ascertain, in McPhail and Dalton, what they had? Were they able to ascertain the beneficiaries in McPhail and Dalton?
No,
Because what happened? What happened in McPhail?
I guess it's too generalized.
Were they able to,
There was too much people, I think. It wasn't specific.
They weren't, they said, what did they say about that? What they said about the people in the class? In McPhail, remember that? I still trying to get y'all to remember it.
That's the one where they couldn't have a count for everybody.
Where they had this group, where they said all the employees,
Right.
and what they said about that? Because there was a discretionary power in there as well.
Mm.
Certainty of objects. So they had to be a member of a class. What they say about that? Nobody? Let me see if I can get it material fast quickly. Let's see it.
So they wasn't able to have a complete list of beneficiaries. So I guess it wasn't ascertainable.
So it was, so there was so large as to almost be certainly incapable of exact ascertainment.
Right.
So held that clause 9 was mine and considered a trust. The test to be applied to ascertain the validity ought to be similar to be accepted. That's not the one I want. I want the one would break it down so we can share it and y'all could remember my fail. I'm gonna get it for you right now. We should have something so we could deal with McPhail and let's see. Let's see. That's not the one. Okay, let me just read it quick. See if this helps us. So by deed dated July 17, 1941, a fund was established for the benefit of officers and employees, etc. of a company. Clause 9 of the deed, so far as material provided. The trustee shall apply to the net income of the fund in making at their absolute discretion grants to or for the benefit of any of the officers and employees or ex-officers or ex-employee of the company or to any relatives or dependents of any such persons in such amount at such times and on such conditions, if any, as they think fit. You hear that, class? That's a big class, eh? So they're for the benefit of the officers and employees or ex-officers or ex-employees of the company or to any relatives or dependents of any such persons in such amount at such times and on such conditions, if any, as they think fit. The trustee shall not be bound to exhaust the income of any year, So you see the class? You see the class of beneficiaries? The class eligible for the benefit under the clause was the officers and employees or ex-officers or ex-employees or any relatives or dependents of any such persons was so large as to almost certainly be incapable of exact ascertainment. So we, in trying to ascertain the beneficiaries, what happened in this case? Would we be able to ascertain the beneficiaries?
No,
We'll be able
Okay.
to ascertain some of them?
some, but not all.
Right, so we can, they said, in this case, the trust was valid if it could be said with certainty that any given individual was or was not a member of the class of beneficiaries designated. I'm gonna send you the case because this one.
So I have a question. If a settler makes up a trust like that where, you know, it has to have the three certainties, and in this case, one of the certainties wasn't met.
Mhm.
So would this now be a sham trust?
No, the trust will fail for lack of certainty, remember?
Right.
So we have, McPhail is a good example of a non-exhaustive discretionary trust where the trustees have the power to distribute the fund, but also to accumulate it. McPhail, previous to McPhail, the test to be applied. In conclusion, the court, oh, don't go back there. Okay, hold on. Let's go back. I messed up. I'm gonna see if I could share the screen. That may help you all with seeing it better. Okay. In conclusion, the decision of the court that it was clear that in this case, Bertram Barden did not intend for every single employee, ex-employee, relative, and dependent to benefit from the fund, but simply that the trustee should choose the beneficiaries from that class only. Discretionary trust, this was a discretionary power. So they don't have to benefit everybody, right? But what they could have done, chosen from the class that they gave. So it could be for the benefit of the employee, the ex-employee, their relatives, dependents. So any of those would have been there. They should choose the beneficiaries from that class only, give a new possibility for allocation of funds to a larger class of beneficiaries. If the complete list test were to apply in such cases, the trust would not be workable because implementing the trust would have a huge administrative burden, which would in itself defeat the trust. The burden post McPhail should then fall upon potential claimants to prove that they belong to that particular class. So would this trust fail for certainty? Would McPhail's fail? Would McPhail versus Dalton's fail?
Yeah.
No, because what they gave you, a class. Did they say everyone has to be paid in this class? What did they say? What did he provided that you can, it is a discretionary power, right?
Oh, yeah.
So he has, in order to allocate the property according to the testator's wishes, equity recognizes both a trust and a power of appointment. The donee of such power will distribute the property by making appointments to the objects of the power. However, the donee is not under an obligation to exercise his power, and he has absolute discretion to assign the property. By contrast, a trustee is under an obligation to distribute the property to objects of the trust. So, do the words create a trust? Yes, they did. Do we have certainty of the objects? Yes, we did, because what happened? They had a class that you could have chosen from to use your discretion, eh?
Yes.
So if it was, in this case, not a discretionary power, but a proprietary interest that these beneficiaries had, what would happen? Would this fail?
No.
Okay, we have a discretionary power, and we have, do you have a discretionary beneficiary and you have a proprietary beneficiary? I've said all of these people are proprietary beneficiaries. What happens if I can't ascertain them? Because you said I must pay everybody in this class. In the discretionary part, in the discretionary beneficiary, I can choose who I giving it to, eh? Yes,
Yes,
because they are just a mere. What would we call them? A mere object of a power, right?
Okay.
In the proprietary one, they have a right. They own something, eh? So if I'm not able to ascertain them, what the trust will fail for? Certainty of who?
Subject matter.
Object. They objects,
Object.
eh? If I'm not, if,
Well, at this point, I was thinking that if you don't have enough property to actually pay all these people, if they're looking for, I guess, the interest in it.
well, I mean, what will happen? So I make up a trust and I have it so wide. I have the subject matter is there. I have the intention and I have the objects. The objects are the beneficiaries, right?
Mhm.
In this case of fail, this was a discretionary trust. So what happened? It's up to the trustee who they decide, or to this class, who they're gonna pay. You understand when there's a discretionary, you're a discretionary beneficiary, I can decide whether or not I'm gonna give you anything, eh? You know
Right.
that?
I get that.
Okay, because that means if I decide you need it, or if I decide the trust can afford it, I can give you something. Where there's a proprietary interest. What is the difference with that? I'm more or less a what type of beneficiary? You have a proprietary right. You more or less, you vested it. Can the trustee decide whether or not to give me what clearly has been defined for me?
No.
So they've expressly stated what I should get. Can now the trustee decide in his discretion whether or not I should get it? So I have a trust that I've expressly stated, you should give $1 million to my employees, my ex-employees, the relatives, the dependents of my, what that means, I have to do now to realize that trust. I have to ascertain the group. I have to know who the beneficiaries are because I have to give out this $1 million, right? If I'm unable to ascertain every member of that group, what happens? In the express trust for the beneficiaries. I don't have a discretionary power here to give them the money. I've been told to give that to them. Would the trust fail?
Yeah. No,
Because we can't ascertain who.
everybody,
And who's everybody?
beneficiaries.
Objects.
Right, the objects. So the trust will fail for certainty of?
Object.
Yes. Would they fail for certainty of objects where there's a discretionary trust?
No.
No.
Because
No.
I have
The power.
Discretion.
Power.
to pick out of this class. So if I don't get to ascertain all the members, it's too sad because I just give who I could ascertain, eh?
Mhm.
Right.
You see?
Gotcha.
So you see the difference there? So
Yes.
McPhail and Dalton deals with discretionary trust. The ascertain, where you have a class of beneficiaries, where they can be ascertained, and how it applies in the discretionary trust. Okay? Okay, let's continue so we can be finished. I don't want to keep you all longer. That was clear or no?
Yes,
That's
ma'am.
clear.
Okay, good. Let's go ahead. Oh, you finished? You finished reading A? No? Yes? Hello?
Yeah, it's done.
Okay, so we go into unascertainable beneficiaries and ascertainable beneficiaries. So where there's more for Saunders and Vaudier to apply, it cannot apply in the case of unborn, unascertained, or unascertainable beneficiaries, because what Saunders and Vaudier says, the beneficiaries must be sui juris, properly ascertained and complete as a group, and beneficially entitled to the trust properly. So you cannot apply in the case of unborn, unascertained, or unascertainable beneficiaries because you are not what? In the case of a discretionary trust, are you beneficially entitled as a discretionary beneficiary? Do you have a proprietary interest as a beneficiary? Who is a discretionary beneficiary? What I just explained. Did I lose you? Anybody?
You said with the objects, what you said, the last part, Miss.
Okay,
Godfrey?
I'm saying to you, would the case of Saunders and Vaudier apply? It cannot apply in the case of unborn, unascertained, or unascertainable beneficiaries.
Mhm.
If you are unascertainable or unascertained, can you now terminate the trust in accordance with Saunders and Vaudier?
No,
No,
Because only persons who are what?
properly ascertained and sui juris. So
Right, and they should be beneficially
entitled
entitled.
to the
You
property.
cannot be a discretionary beneficiary where the trustee has the discretion whether or not you get something. You have to be beneficially entitled to now terminate the trust.
Right.
So more or less, you must be vested. So the rights of the beneficiary in relation to Saunders and Vaudier may be restricted depending upon the circumstances. They can only end the trust in certain specified conditions, or the settler may expressly exclude this rule by placing an express clause within the trust that the beneficiaries will not be able to end the trust by collectively requesting the legal title to the trust property. So the settler may say, you know, something as much as I want my children to be they're vested in this. I still don't want them to come together and terminate this trust before a certain time. So I'll put an express clause in there that they can't terminate the trust if they come together in accordance with the rule in Saunders and Vaudier until certain things may have happened or at a certain time. Because, you know, the trust can't go on just indefinitely. We have a ending point because that would be against the rule. What that is?
Perpetuities.
Right, so we have, what's the rule now? What is it? What's the time frame?
I know what you mean, the 150 years?
What
Plus
is it?
21?
So y'all know the rule? Yes? Everybody knows it?
I have a question with that.
Okay.
The rule only applies in certain instances, right? Saying that it was already abolished. So in certain instances, you could use that perpetuities rule.
Right, but what happened when it abolished? What happened? They put something in place that you could now do what? Extend?
Right.
Right.
And so that's what I was saying. In certain circumstances, you could extend it.
Right, but you have to now put that in place because it just doesn't automatically happen. You have to now put it in place in accordance with the new rules, eh?
Right.
Okay, and the trustee must control the administration and management of the trust. So as much as the beneficiaries may have an equitable interest, they're not entitled to dictate to the trustees how they should exercise the powers and discretions contained in the trust instrument. So this allows that the trusts to run smoothly, free from interference of the beneficiaries, particularly those who want to advance their own interest at the expense of the other beneficiaries. So you may have siblings who don't get along well, or you may have siblings who have married parties and they are at war. And so now they could put your trust in turmoil and put your life in hell trying to keep up with all their demands if you were to follow their directions, right? And you don't want them to wield any inappropriate influence over the trustee who may not be mindful of their legal and fiduciary duties to the trust and to the beneficiaries generally. Any questions? We went through that one quick. That was okay?
That's all.
Okay, let's answer the questions. Number one, failure to act in the best interest of the beneficiaries will result in a potential blank action against the trustees by the beneficiaries. Where we'll find that answer.
Page 90,
It's,
Uh-huh.
yeah,
breach of trust.
breach of trust.
Okay, failure to act would result in potential breach of trust action. Number two, a trustee must treat all beneficiaries blank and blank. Where we'll find that answer.
Page 90.
Fairly and impartially, page 90.
Okay. Number three, beneficiaries have a vested interest in the trust property as blank owners. Where we'll find that.
Page 90.
Equitable owners. Number four, both statutory and common law require that the beneficiary has the blank regarding the trust except information that may be prohibited by law. Where we'll find that answer.
Page 90, the right to information.
Everybody?
That the right to what?
Information.
Information.
And you all see
Thank you.
where it is?
Page 90, right?
You're okay, good.
Okay, thank you.
Okay, number five, a beneficiary is not entitled to see all documents belonging to the trust as blank, and blank are not permitted to be seen by the beneficiary.
Minutes, correspond.
And
Which-
correspondence.
The exercise of the trustees' discretionary powers in the admin, where we'll find the answer.
Page 91.
Page 91. Number six, an important reason for this prohibition is to allow beneficiaries to have access to such documents blank to the exercise of the trustees' discretion. Where we'll find that.
Page 91, may create a challenge to the exercise of the trustee's discretion.
Okay. Number seven, blank of the Trustee Act 1998 gives beneficiaries of Bahamian Trust the right to information under certain specified conditions and in certain specified circumstances. Where we'll find that answer.
Section 83, page 91.
Okay. Number eight, where there is more than one beneficiary, in order for the rule in Sanders v. Vaudier to apply, all of the beneficiaries must be blank and blank as a group and beneficially entitled to the trust property. Where we'll find that answer.
Page 93, sue jurors, properly ascertain and complete.
As a group.
That's a good-
Okay. Everyone has it?
Yes, ma'am.
Okay.
Yes,
While the rule in Sanders v. Vaudier enables beneficiaries to end the trust in certain specified conditions, a settler may expressly exclude this rule by blank within the trust, that the beneficiary shall not be able to end the trust by collectively requesting the legal title to trust property. Where we'll find that answer.
It's 93, express clause.
Express clause. Ready, everyone?
Yes.
Beneficiaries, whilst they may have an equitable interest in trust property, are not entitled to blank to the trustees how they should exercise the powers and discretions contained in the trust instrument. Where we'll find that?
Dictates and page 93.
Excellent. Okay, so we were able to whop number 12 out. Any questions on 12?
Nope.
No questions? We know beneficiaries' right to information. We know what the case of Smith tells us, as much as they may not have a right, we still have to use certain considerations, and we can refuse to accede to their request based on legal grounds, privilege, confidentiality, etc. We know Saunders and Vaudier can apply to terminate the trust. However, that can be prohibited where the trust, where the settler has put in an express clause in the trust where they cannot do it, or where one or more of the beneficiaries, where there's unascertained beneficiaries are unascertainable, or in the case of unborn beneficiaries. Any questions? Too much information for one day?
Yeah, you just open up our eyes even more. Boy, it's not that I am afraid now. that
No,
I read.
man.
I got burned the midnight oil.
You all have this because you all answering the questions. You all,
Yeah, thanks to you.
yeah, you all
Breaking it
able to
down.
answer.
And then you giving us more examples.
Yeah, so you all getting it. You all are able to answer. You just have to review and pull back. You all already did midterms, eh?
Midterm?
No? Or so you all
Midterm
have the whole-
test?
you all have the whole thing to do?
Yeah.
Yes, ma'am.
Oh, okay then. So you all, most of it ties back. So you see how 2 was right back in 11. You see, so most of the information is a repetition. It just expands on it. So it's not so bad.
Okay.
So you'll see that this is just from the beginning, the same thing, just repeating itself. And it just opens it up wider so you'll be able to explain a bit better. Yes?
Yes,
Right.
ma'am.
Okay, so next week we will conclude 13 and then we'll just test our skills on what we've learned so far.
Okay.
Okay?
Yes, ma'am.
Really doing breach of trust. So if you all read that first, then we'll get through that even quicker. And we already have the answers to the questions, and then we'll do a little recap. Okay?
Okay.
Okay.
Yes.
Thank you so much for indulging us today.
Thank you too.
Take care.
Enjoy the rest of your day.
You too now. Take care.
Okay,
Yes,
bye.
ma'am.